anything else.
There was a limiting instruction, such as Mr. Rosenwasser indicated. I don't see any harm in that either, as to that portion of his testimony. Say it again.
This testimony is being offered only to demonstrate the concept of backlighting.
All right, I think that's fair as to that portion of his testimony. So can we
I would agree
pause?
with that. And Judge, I would agree with that. I don't have any problem with that. That was our intent from the very beginning.
All right, so we can pause briefly before he begins that portion, which will include the PowerPoint.
I will make sure that that happens.
All right, all right.
Can I go and talk to Mr. Knox now?
Yes, please.
Try to get that.
Before you go, just one thing, the fact that they used a mannequin, I mean, it is kind of interesting to demonstrate the backlighting. So I've intended to ask him, and I don't know how you want to handle it. I don't want to open the door into, Pandora's box, so to speak. That, in this case, he chose to use mannequins. He could have used any object at all, but he chose a mannequin. I mean,
Judge, he chose a mannequin because of the fact that if he would have chosen a TV like this and it would have been, very, very dark, then we would have gotten objection. The reason is a mannequin is a human body. Human bodies have arms, they have areas of the neck that are a little bit.
Okay.
That's why
So
we used it.
Mr. Knox can certainly answer that without opening Pandora's box.
okay.
Just that simply.
I will talk to him and make sure that he is.
Okay.
Can I give you an idea of what Mr. Knox said about why you use a mannequin and not a board or something, if that's what the court wants?
I don't care.
Okay.
If Mr. Rosenwasser wants to bring that out on cross, I'm sure we'll hear. It's not that I don't care, it's just at this moment I don't care. It's okay. And that's up to Mr. Rosenwasser when he does his cross, but as I indicated, that's not going to open the door for every other thing to come in.
Yes, Your Honor.
It'll be answered accordingly, and we'll go from there. All right, let's bring the jury back in, please.
Jurors in the courtroom, Your Honor.
Okay.
Jurors may be seated. Jurors are present and accounted for, Your Honor.
Thank you, ladies and gentlemen. Were you all able to abide by my instructions during that brief break? Hopefully. All right, thank you. We're going to get started again. Mr. Escobar?
The defense would call Dr. Michael Knox.
Walk around this way. I'll walk all the way over here where we can see the clerk. Listen to that right hand, raise your right hand, face the clerk.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Come on, I'll let you sit down and listen to you. Go.
Good morning, Dr. Knox.
Good morning.
Doctor, would you please pronounce your name and spell it for the court reporter, please?
My name is Michael Knox, and first name is common spelling, last name is Knox.
Dr. Knox, would you please, I'd like to review a little bit about your educational background. Let's start with your educational background, if you can. Your college experience, obviously.
Sure. I have a bachelor's degree in mechanical engineering from the University of North Florida, a master's degree in forensic science from the University of Florida, and a PhD in criminal justice from Nova Southeastern University.
Let's talk a little bit about each one of those degrees that you received. First of all, your associate's degree. Let's talk about what the areas of concentration were for those.
For associate's degrees, I actually have two. One is an associate in arts, just a general education, and then I also have a associate of science in criminal justice technology.
Okay. And when you went to get your bachelor's, what was your, I believe you indicated your major there was engineering?
Right, mechanical engineering, that's correct.
Explain to the ladies and gentlemen of the jury what that all entails.
Well, mechanical engineering is the branch of engineering that deals with the design and operation of machinery. So in a engineering degree, you're doing heavy math, doing all the calculations to calculate things like stresses and strains in a machine and heat transfer, fluid flow, and all sorts of things like that. So it's very math intensive, a lot of physics and mechanics involved, and you're dealing primarily with things that would involve moving machinery. So that's sort of the area of engineering.
You also received, as my understanding, a master's degree. Is that correct?
That's correct.
And that was in forensic sciences. Explain to the ladies and gentlemen of the jury what forensic sciences are.
So the forensic science program at University of Florida, they have different tracks, but the one that I did is the general forensic science track. So it's sort of a variety of different courses related to forensic science. Some of them are just general forensic science concepts, statistics, and various things like that. And then I took courses in things like bloodstain patterns, forensic entomology, which deals with the collection of bugs at a crime scene, and the utility that they have. Forensic biology and forensic chemistry, all different things like that. So sort of a general overview of the forensic sciences with a lot of detail on the technical side and the application of it.
You then also received your PhD in criminal justice. I know there was a focus of that PhD as well. Explain to the ladies and gentlemen of the jury what that PhD entailed.
So the PhD in criminal justice is primarily a research degree, a scientific research degree. So what you're doing there is applying scientific method to criminal justice related problems and looking at various types of data. So you would be looking at things like it might be a particular criminal justice program to treat an offender. Does it work? And then you'd have to do the statistics to be able to figure out, is it actually effective or does it not change the outcome? You could be dealing with all different sorts of problems, whether or not a particular laboratory procedure was effective, just by applying, again, statistics and a methodology to that. And then I had a concentration within that of behavioral science, and I actually did my dissertation on the crime scene behaviors of school rampage shooters within that.
Let's talk a little bit about your law enforcement career. Tell the ladies and gentlemen of the jury when you first started your law enforcement career.
So I started as a police officer with the Jacksonville Sheriff's Office here in Florida in December of 1994. And I was a police officer in uniform for about 5.5 years. And then I went to the crime scene unit. So at the Jacksonville Sheriff's Office, all of the crime scene investigators are sworn police officers. So after you've done a certain amount of time as a police officer in uniform and patrol, then you can transfer to the crime scene investigations unit, which is part of the detective division. And so I spent 7 years there as a crime scene investigator, training coordinator, and then I left that unit in 2007 and spent 3 years as a traffic homicide investigator before I left the agency, took an early retirement in 2010.
Let's talk about those years as a crime scene investigator and tell the jury, if we can, what is a crime scene investigator?
So as a crime scene investigator, your primary role is to document and collect, preserve, and in some cases analyze physical evidence from crime scenes. So your primary focus is on the physical evidence, and your job is really to secure everything and to first document and then to assess it and apply appropriate procedures for being able to collect, process evidence, for example, processing for fingerprints or collecting samples for DNA or doing things like that, as well as doing other things, maybe documenting bullet trajectories or bloodstain patterns or things like that.
So 3 of your years in that department was as a major case crime scene investigator?
Actually, I was a major case crime scene investigator for almost the whole time that I was in the unit.
So for the entire 7 years?
Yes. So what happens is you come into the unit and once you've gone through training and you've gotten sufficient amount of experience that they feel comfortable letting you be the lead crime scene investigator in major crimes, which would be homicide cases, serious sexual battery cases, ones with injury or things like that, or police-involved shootings, or there's certain enumerated offenses that would be classified as major case designated, and you have to be designated as a major case investigator to be able to be the lead crime scene investigator on those.
And that's what you were for Jacksonville?
Yes.
And you also, I believe you indicated you had a title of training coordinator. Tell the ladies and gentlemen of the jury what that training coordinator position also entailed.
So from 2003 until I left that unit in 2007, I was in charge of training everybody else in the unit. So that meant I was providing a lot of the training to other people. New people that would come in, I would give them training, as well as do ongoing training with those people who were already in the unit. And then also I made sure that if there was any outside training available that people were able to go to, that, kind of organize that and send the appropriate people and those sorts of things.
Now, it's my understanding that you also had some coursework, some work within your department, for example, in the Institute of Police and Technology. Let's go through some of those if we can. Tell me what you did for that particular institute.
Well, I went to a lot of training courses there over the years. So it's the Institute of Police Technology and Management, which is a training center for the University of North Florida. And IPTM trains police officers from all over the country, but even internationally, in a lot of different fields. They have a forensic science, forensic investigation section. So starting from the late 90s on forward, I took a lot of courses there in traffic accident reconstruction and things like that. And then probably starting early 2000s, crime scene processing and homicide investigations, crime scene reconstruction, bloodstain pattern analysis, and a lot of other courses related to crime scene work, use of alternate light sources and things like that. And so I took, I don't know how many, but probably at least 15, 20 different courses from IPTM from the late 90s up until about the mid-2000s.
Some of those courses also included lighting optics, is that correct?
I've taken the course on lighting optics and visibility for forensic investigator. That was actually not IPTM. It's another training company that put that on, taught by a lighting engineer, person who had a background actually designing lighting and systems and stuff. And that course dealt a lot with the documentation side, how to photograph lighting conditions and how to be able to take measurements and things like that.
There was another course you took, lighting and visibility for the forensic investigator?
Yes, that's the course I was talking about.
Okay. You had a Glock Advanced Armorers course. What's that about?
So I've actually gone several times up to the Glock factory up in Smyrna, Georgia, and they put on what they call armorer training. So basically an armorer is a person who is certified by the company to work on their pistols. So if you go through the Glock armorer training, then you're certified to work on all models of Glock pistols, which includes diagnosing if there's something wrong with it and changing out parts if the parts need to be changed, things like that.
You also took a course called Street Survival Seminar, is that correct?
I actually took that one twice, way back in the 90s, actually right before I went to work for the Jacksonville Sheriff's Office, and I took it again in, I don't remember exactly what year, but early 2000s.
What is that course about?
So there was a company called Caliber Press that they publish a lot of books and things that's training literature for police officers. Most of what they deal with is, tactics for police officers to survive armed encounters and things like that. And so I've been to that training twice. First time because I was becoming a police officer, and second time because it more from the investigative side of staying current on what was being taught to police officers for them to do, so that if I went to police-involved shootings, that I could, stay current to that information and know what type of evidence to be looking for.
You took a course on digital photography, is that correct?
Yes, I've actually had several different courses. IPTM has a digital photography course that's digital photography for law enforcement. I've taken that one twice. And then I just a couple of years ago actually took a couple other digital photography classes. One on autopsy and injury photography, and I'm trying to remember the other one.
You also took your courses on homicide investigations in general?
Yes.
And how many of those did you take?
Well, I took one 40-hour class at IPTM that's on homicide investigations, and then I took another one on it's titled Injury and Death Investigation, which was at the Police Academy in Jacksonville in the 90s when I took that class.
Certificates that you currently hold?
I I've had multiple different certificates. I actually was certified by the International Association for Identification, which is a forensic institute that has a crime scene certification program. I held their crime scene reconstruction certification for 10 years, but they decided several years ago not to continue that particular certification. So for those of us like myself whose certification expired toward the end of last year, they didn't offer a renewal. But I did hold that certification. I had to go through the process of getting that, which is you have to meet certain requirements, and then you have to take a test and then a practical in order to be able to get it. And then I did another test and practical 5 years later to renew it.
And you, that lapsed when? You said last year?
Just the end of last year.
So in 2014, you had that certification, is that correct?
I did, yes.
At some point in time, you left law enforcement, is that correct? Tell the
That's
ladies
right.
and gentlemen of the jury why that happened.
I started doing consulting work as a part-time, and I began to get too busy when basically was working 2 jobs. And so I was able to take an early retirement, invest my time, and leave and still get a pension, eventually. So I made the decision to leave the Jacksonville Sheriff's Office and then go full-time into the crime scene reconstruction consulting business.
And what is your specialization in your consulting work?
So crime scene reconstruction would really be what I would call my specialty, with other things that go underneath that, with a particular focus on shooting incident reconstruction. So the majority of the work that I do is reconstructing shootings or firearms involved incidents. And of course that includes doing things like bloodstain pattern analysis and bullet trajectory work and things like that.
Members of associations?
Primarily, I'm a member of the Association for Crime Scene Reconstruction, or what's known as ACER, which I've been a member of since, 2008 or 9, something like that.
Are you still a member of the American Society of Mechanical Engineers?
I did not renew that one, I think, in the last year or two. Primarily what I've decided is, in terms of focusing on professional organizations, is that's related directly to my field. So ACER would be the one primary organization.
Have you been published in the past?
I have.
And let's talk about some of those, and we'll probably go from the, I'll give you just a few. Forensic engineering applications in a crime scene reconstruction. Did you author that paper?
I did.
Okay, and was that paper also peer reviewed?
It was.
And would you explain to the ladies and gentlemen of the jury what that means, being peer reviewed?
So a peer-reviewed paper, technical paper, or scientific paper is one where you submit it, and it has to go through various steps of approval, and one of those steps is that it gets sent usually to 2 reviewers who are experts in that field or that have the appropriate background, who will then review that paper and make a determination as to whether or not it meets the scientific rigor for whatever publication or whatever conference it's being published at.
Another one that you did, the forensic engineering analysis of ejected cartridge case patterns for reconstruction of firearms-related incidents. You wrote that paper as well?
Yes.
And was that paper also reviewed?
Yes.
Forensic analysis of an accidental firearm discharge due to a blow to an exposed hammer spur. You did that one as well?
Yes.
Forensic engineering analysis methods employed for the purposes of determining the location of long-range shooter based on terminal bullet trajectory. Did that one as well?
Yes.
And I won't go through all of them. Okay. Books. Tell us about books.
Well, primarily, I was involved in, and an associate of mine had written a crime scene processing manual, basically on A to Z's of processing a crime scene. And then for the second edition, rather than updating the book, we took the entire book and turned it into an online format. It basically was delivered on a DVD so that somebody could put it in the computer, and that allowed us to actually include not just the text and the photographs that were in the book, but add videos and multimedia stuff to be able to sort of explain and demonstrate all different kinds of crime scene processes. So if a crime scene investigator needs to know how to document a footwear impression, we had that in there, explaining how to do it, and had videos actually demonstrating the process. If they needed to be able to take measurements of something, then we had it in there to be able to explain that. So we sold that for probably about a 10-year period. I don't think that there's been any sales on it in the last couple of years, but for a while it was published not just by us, but also a third-party company that sold forensic equipment and supplies carried it in their catalog.
Teaching, have you held some teaching positions?
Yes.
And would you tell the ladies and gentlemen of the jury about your teaching positions in the area of crime scene investigations, and specifically in forensics?
Well, the main teaching that I do is for the Institute of Police Technology and Management, where I am an adjunct instructor, and I am the lead instructor for shooting incident reconstruction classes. So I teach that class every year in Jacksonville, and then we teach it periodically on the road if an agency requests it. So I think the last time I taught it out of town was in Sacramento, California, for the California Highway Patrol. And then I've also have taught as an adjunct instructor. I taught a forensic. It was a forensic science class for Kaiser University, and then I also taught a class on crime scene and forensic investigations for Flagler College.
Have you also taught and lectured abroad?
I have.
And would you explain that to the ladies and gentlemen of the jury?
So I taught a shooting reconstruction class in the Republic of Georgia, not the state of Georgia, the Republic of Georgia, over next to Russia, and that was under contract with the U.S. State Department for the Georgian police. And then I've also taught a couple of courses, general crime scene courses for a company called Searchy Fingerprint Laboratories, which is a company that manufactures and sells crime scene equipment and supplies. And I taught that course in Dubai, in the United Arab Emirates, for the police and their forensic science laboratory there. And then I've taught that class twice to different groups of prosecutors and medical examiners in Peru, in two different cities in Peru.
And have you been qualified as an expert in the field, in your particular field?
Yes.
And can you tell me if that was in crime scene reconstruction?
Crime scene reconstruction, shooting incident reconstruction, bloodstain pattern analysis, and several other related sort of subfields of the crime scene reconstruction.
Let's start out about talking about how is it that we engage and investigate a crime scene from the very beginning. What do you do as a crime scene investigator? What are you required to do as a crime scene investigator when you first take on that responsibility?
The first part of whenever you get there is just what I call data collection, or collecting information, essentially. That's going to start with information where you're going to get at least some idea of what's the nature of what happened, and then you'll begin to assess things like what's the extent of the scene, where did this all take place, what kind of physical evidence is present, and you begin documenting that. So initially what you're really trying to do is just document and collect everything and gather all the data that you can gather without really making any decisions on anything. You're not trying to figure out really at that point exactly what happened or who was involved. You're trying to figure out what evidence is there and what information do I need to collect, what do I need to document, and what's going to give me the information that we're going to need to be able to start piecing everything together. And then as you document through photography, through measurements, through actual collection of different types of evidence and various different types of processing, depending on what you're looking for, then you would move into where you start to piece things together and figure out what it means. So now I have information and I know this, and so what does that mean? What does it tell me about what took place? And then you begin just steadily and methodically working through all that to be able to eventually get as complete a picture as you can of what actually took place and what is it that you need to find out.
So are you telling me then, well, let me ask you this question. Does a crime scene investigator just go into a crime scene and allow the crime scene technicians to do whatever they want to do or whatever they feel is appropriate to do? Or is the crime scene investigator heavily involved in the entire process of the investigation?
You should be heavily involved. So basically what you're going to have is in a situation like you have here in Pasco County, where you have non-sworn forensic investigators and you have a detective that's assigned to the crime scene whose job it is to oversee what's going on, then the biggest piece of what's happening here is communication back and forth between the detectives that are doing interviews and that are finding out different pieces of information and making sure that that's communicated with the forensic investigators who are actually doing the evidence collection and documentation. Because you have to have some idea of what's going on to really know what to collect, to know what evidence to process, and to know what's important. If you don't really know anything, then you wouldn't know what's out of the ordinary, what's part of the scene that's ordinary and isn't really part of what took place, and those kinds of things.
How critical is that aspect of doing a proper investigation? Knowing what others are gathering in the form of information.
That it is, you really couldn't overstate the necessity for that. You have to make sure that you're communicating, that you know all the information that's coming in, because you can find out things in a crime scene where somebody, there may be something that's related, and you have no idea that it's related because that hasn't been communicated. So you have to find out not just what's there in terms of physical evidence, but every piece of information that you may know about a crime. Even when you have a crime where nobody witnessed anything and you have nobody alive to tell you what took place, as a crime scene investigator, I still need to know what information is known. Things like when were people last seen alive, or what's the parameters of what took place? Where might things have happened? Where did this person go? What do we know about it? So there's an absolute necessity for communication going between the detectives that are doing all the interviewing work and the crime scene investigators and technicians that are documenting and collecting all the evidence.
Obviously, there could be two types of cases. One is who did it, right? And the other one is what?
That's right. Basically, you can understand physical evidence in two terms. What we call associative evidence, which is evidence that tends to associate things with people or things with other things, or maybe things with a location. And associative evidence typically goes toward the question of answering who. Who was involved, who did it, so sort of the classic of that would be like I was giving the example of a homicide. You get there and there's a body. And what you know is that this person's been killed, and that's all you know. Somebody found them. when you go to a scene like that, your primary focus is on associative evidence. What am I looking for that's going to help me identify who was here to try to figure out who actually committed this crime? The other type of evidence that you deal with is what's called reconstructive evidence. So that's evidence where you're using it to figure out what happened, not necessarily who. Now, you can be doing both in some cases where you're looking at associations and reconstruction of what took place. But certain cases, and this would be one of them, where the who is not really a question. So the real focus is what happened, and what you're doing with the physical evidence there is going to be centered on determining what took place.
So the dynamics of what happened is critical in the gathering of relevant evidence. Is that a fair statement?
Yes, I think that's a fair statement.
And so how do you go about then gathering the information that you're going to use to try to preserve evidence of what happened? How do you go about that?
It begins with having, you have to know and understand what's the extent of your scene and where your evidence is going to be found. Because then you know where to search, you know what areas to document, what stuff to measure, what things need to be collected, and what's the area that you focus on. But you can also have things that you're looking at that aren't necessarily like a piece of physical evidence that you're trying to find, but documenting things like if you have an incident where you have a number of different witnesses, then you could be also needing to identify where were these people and what were they looking at when they saw or heard or perceived various things that they've discussed or have told the detectives, so that you can document from their perspective. And there's a couple purposes on things like that. You're actually documenting where they were so that it's known, but looking at things like how far away is the person? What's the line of sight for that person? And you can also get into what's the lighting, what would they see under the lighting conditions, things like that. Because the idea is, one, to be able to test what anybody says for accuracy. Is it correct or not? And two is just to be able to have a record of that later as to, from this perspective, you could see this. So that's why you're communicating back and forth, and then you're looking at everything that you need to document, collect, and in a particular scene.
Obviously, you know this is a self-defense case.
Right.
And so how important, we're just going to get back to the witnesses in just a second. How important is it for the crime scene investigator and the lead detective to determine whether there has been contamination that may have taken place there at the crime scene? How important is that?
That's something you'd want to make sure you knew as much as you could about what happened in terms of the scene. And by contamination, you can have a lot of different things that can take place. One being is whether or not physical evidence is moved or touched or anything has happened to it between the time that the incident took place and the time that you're arriving there to document. If anything got moved, then you need to know that it got moved, and you need to know where it came from and try to get the best possible evidence as to where it originally was. Where did it come to rest when everything ended? As well as making sure that all the evidence is handled such that you don't destroy anything that might potentially be important. Because it could, even though you have a shooting scene where you're really focused on reconstructing what happened, there can still be important associations and associative evidence that you could be looking at, trace evidence of things, maybe DNA or fingerprints or things like that, that could tell you what events took place. One I get on a not infrequent basis is where somebody's, say, struggling over a gun, so we need to know that there's some type of struggle that took place with the gun. because we could be looking at DNA or fingerprints from the people who were struggling over the gun to try to verify whether or not they actually were struggling over the gun. So that's really the importance there.
So we talked about contamination, obviously, with evidence. Is there such a thing called contamination of witnesses?
Yes.
Explain to the ladies and gentlemen of the jury what contamination of witnesses entails.
Well, the biggest thing with witness contamination deals with not wanting witnesses to talk with one another about what happened, so that each person that you interview and get information from is giving you their recollection of what happened. And they're not getting pieces put in it from conversations that they had with other people. Because what you want to know is what does that person know? What did they actually see or hear? Where were they? And you want to understand how certain they are about it. Whereas if they've talked with other people, then they may have had additional information added to what they recall, to the point that by the time you interview them, that those things can no longer be separated.
Would you agree or disagree that individuals that sometimes listen to others actually start believing that they themselves may have seen or heard what they've been contaminated with?
It happens frequently, yes.
And tell the ladies and gentlemen of the jury how dangerous that is in our criminal justice system.
Well, the biggest problem with that is that you're not getting that person's actual knowledge and recollection of what happened. And see, when you're doing crime scene reconstruction, I can't take what a person tells me and then I don't have some magic way of knowing whether it's true or not. What I have to do is take what they say and compare it to the physical evidence to see whether or not what they say is possible or not possible, whether it's consistent with or inconsistent with physical evidence. And so you have to be able to assess those factors within what a person tells you that are reliable pieces of information and those pieces of information that aren't reliable. When people begin to talk to one another and begin to adopt things that they've discussed amongst themselves, then you begin to have multiple witnesses telling you things that perhaps if they had been separated and they had not communicated with one another, you would get a piece from one witness, and you might get a different piece from another witness, and then maybe a different piece from another witness. And that helps you to be able to separate what people actually know and saw and heard, as opposed to getting kind of the chicken soup at the end, where multiple different people's recollections are kind of thrown into one bowl and you can't really tell who actually saw and heard what.
And so the issue of separating witnesses, is that a concept that you learned early on in your law enforcement career?
Pretty much a day one concept. Yeah, pretty much.
Meaning your initial training as a police officer, the police
Right.
academy, I should say.
Right.
They teach you this concept of you come to a crime scene and you do what? Witnesses are there. What do you do?
Yeah.
Separate them, right?
Yeah, you're in police academy training. You would, as a patrol officer, would be taught your first priority when you arrive at a crime scene is safety, making sure that there's nobody that's about to be hurt. Second priority is making sure that if there's an outstanding suspect and somebody that may potentially be dangerous, that person is dealt with. Your third priority is secure the scene and make sure nobody touches anything and does anything to change the scene beyond what it is right now when you got there. And that you're very close to that would be your priority of separating witnesses and getting people off the places where you'll be able to interview them and get their recollection of what they actually know about what happened.
And so you've talked about the dangers of contamination. What happens when you come onto a scene and you realize that multitude of witnesses are talking to each other? How do you handle that problem, if you can?
Well, if you've already got where people are beginning to talk to one another, you want to separate them still as fast as you can, because they may have talked about certain things, but the longer you let them stay together, then the more they're going to talk about what happened. So as fast as you can, you need to separate them. But then what you would do is in that process of interviewing people and figuring out what they saw, you'd need to sort of understand, if you came up and there are people that are talking to one another, keep track of who's talking to who, so that you'd know that these people were in conversation with one another. And you ask them too in an interview. You can ask the person, have you talked to anybody else at this scene? And then you can also start to look at things like when you have multiple witnesses telling you the same thing, to question them about, did you actually see that, or did you actually hear that, or is that something that you heard from another person? Because sometimes the person will tell you, they'll say, oh no, I didn't actually hear that, so-and-so told me that. And then you're able to clarify, okay, that person doesn't actually know, they're not actually a witness to that, they were told that that's secondhand information. So you can deal with it. Obviously you can't unring the bell of anything that they did hear, but you can at least try to get a handle on what they heard and what contamination may have happened.
Would you agree or disagree that becomes even a much greater problem if you have an emotional scene, for example, in a shooting? And if so, why?
It is always, one of the biggest problems with dealing with scenes, especially in the initial few minutes of arriving at a scene, is that there's a lot going on, a lot in terms of what's happening. If you have a lot of people there, then you have a lot of emotion going on, you have a lot of things happening, and you have to separate people, not just from the standpoint of them not communicating, but it also helps calm the whole thing down. Because when you let people sit quietly and reflect quietly on something, then they'll have a tendency to calm down more than if they're talking to one another, and perhaps conversations can get people going. You sort of want them to get them thinking of what they remember and kind of get calm in that, and it'll be easier to interview them once they've had some chance to calm down.
The process of trying to investigate those witnesses that have been contaminated, would you agree or disagree that part of that process is actually testing their recollection? Meaning, where were you seated? How far were you from the seat 9? Taking them back actually at some point in time into the crime scene. Is that something that should be done when you realize that there is contamination in your crime scene?
It's good to do even without contamination, but to take a witness and actually interview them at the place where they were. You can interview somebody in a separate location, get preliminary information, go through their account of what happened, but it's a really good idea to take that person back to where they were to walk through it, because a lot of times it'll help them to sort of trigger their memory, where they remember things, because now they're actually seeing. So they're looking out there and they're actually sitting there looking at the seats in the movie theater where they saw things, and they're able to sort of get an understanding. And sometimes you get witnesses where you take them back and they've told you stuff, and then you take them to a location, you say, okay, now was the person over there? And they'll stop and look and go, I remember this being over here, or this. In other words, they realize that there was something faulty about the way they recalled it, and now seeing the scene and being back in that environment, they recall it differently. So it's a good idea to do. Plus, as I said before, if you take a witness back to the location where they said they were, you can determine whether or not they could have even seen what they said they saw. Sometimes what happens is you take a person back and then you realize that there's a line of sight problem. They couldn't even have seen it, or there's something in between, or there's some type of issue that maybe they couldn't really have seen what they said. So it's a really good idea to get them to show you, and not just go back in and look at it, but have them demonstrate it. Where were you? Okay, you were sitting in the chair. Well, how about having a seat back in the chair? So you turned and you looked over your shoulder. Okay, can you show me how you looked over your shoulder? And go through that whole process with them.
And do you document that, and do you preserve that process as well in a crime scene diagram or in some other form so that others like myself at some point in time can see that?
Yeah, the primary ways that you can document that is photography is one, and by that you could photograph the area where the person was and then take pictures from where they were back in the direction of where they were looking to see what they saw. You can include them in a diagram. So that's quite typical, would be to put a diagram together and then show each person's location on that diagram. Measurements. You could collect a measurement from where they were, say just a straight line measurement, over to where they were looking so that you have some record of how far it was. And then you can also, during the process of interviewing them, you can audio record it, or you can even video record that interview with them so that it's all completely documented and recorded for any need later on.
Let me ask you a question about recording, which is maybe somewhat interesting. Law enforcement officers don't have to tell the individuals that they're interviewing that they're recording them, right?
That's correct.
Perfectly legal, right?
That's correct.
You don't have to, spook anybody that you're recording them. You can put the recorder in your pocket and fire away.
That is correct.
Is that correct?
Yes.
Okay. Is that a tool that's used quite often by law enforcement?
It is. It is. A lot of times if I was interviewing somebody with, in person at a scene or something, I would have a recorder out. I would let them know that, but I would by no means required. In fact, depending on the particular location and stuff, you can even record people without you being present. So, for example, the backseat of a police car. It was not uncommon that we would have a recorder in the backseat of a police car, primarily where you had maybe two people that you believed were involved in a crime, and you could put them in the backseat of the police car, turn the recorder on, or some of the units now even have wireless microphone systems so the officer can stand outside and listen. And then they have a conversation, hey, tell them this. Then you know that. And so then you're able to challenge them with, well, you said this, but you and your buddy just made that up in the backseat of the car, didn't you? So you freely record certainly any conversation that you're a part of.
What we've been talking about, and I'm going to call it verifying a witness's statement or refuting it through forensic processes. Is that more important in scenes where you have the incident occurring with limited light?
That's one of the biggest issues, really in a lot of scenes, but certainly something here, like in a movie theater where you have atypical lighting conditions. So not like we have in this room where we have fairly, fixed amount of light that's steady throughout the room and it's pretty consistent throughout the room. Obviously in a movie theater, while you have something playing on the screen, the lighting conditions not only are quite a bit darker than normal lighting like this, but you have lighting that's constantly changing because of what's on the screen. So that is something that becomes really important to understand how that would affect what anybody saw or perceived, and you'd want to be able to document those things.
Would that likewise be important when you have a scene where, for example, in this case, previews being played loud?
Sound also, yes, is an issue because particularly where you have people that are reporting things that they heard, that you want to make sure that they could hear it and that there wasn't going to be any interference with what was playing, and that in fact everything that they were hearing was coming from what was going on in the movie theater as opposed to what was being played on the screen.
Would you agree or disagree that two of the most important senses that we have as human beings are your sight and your hearing, right? Why is that the case? Why are they so important?
Well, in most of the time when you have somebody that is what we would call a recipient witness, a person who perceives something related to that's going to be, they either saw it or heard it or both. It's not uncommon where we'll have shooting cases where a person never actually saw anything, but they heard something. Sometimes you have cases where they don't hear anything. Maybe they're inside a house and they're looking outside and they see it, but they don't hear it. But obviously, if you have a shooting incident that takes place in a room and there are people there, then potentially they're going to both see and hear it. That's probably about the only thing they're going to really perceive, but they will certainly see and hear based upon what they're looking at and what they're able to hear.
And that influence of light and noise, could that have an impact on the accuracy of what they're saying?
It could, because, again, just like talking about line of sight and going to where the person was, the lighting conditions can affect what they could see. I can obviously see a lot better in this room with lights on than I would be able to see in it if all the lights were turned off. So you'd have to really, you want to know that. You want to understand what could a person actually see based upon those lighting conditions and how it's going to affect what they saw.
Would you agree or disagree that there are tools that are available to preserve lighting conditions and noise conditions?
Yes, there are.
And would you tell the ladies and gentlemen of the jury what tools forensically are available in order to preserve both lighting and noise conditions?
Lighting conditions can be documented with photography and can be documented with taking a light meter and actually getting readings of how much light there is. And then sound, similarly, can be documented. You could record it, and you can also use a sound level meter to see how loud this particular sounds are.
Would you agree or disagree that in a self-defense case, the perception of the accused is extremely important?
It is important, yes.
And so, would you agree or disagree that the individuals that are investigating a self-defense case should certainly have the competence to know how to deal with those particular cases, correct?
Yes.
And so if you had arrived at a crime scene and the lead detective in the case clearly did not have the competence to understand and investigate a self-defense case, tell the ladies and gentlemen of the jury what you would do.
Well, one of the things you have to do anytime that you're investigating any type of a crime scene is know your limits. Those limits can be based upon your own knowledge and training. Those limits could be because you don't have the equipment. Those limits could be because you just don't have the experience with it and you're not comfortable in terms of having enough practice, basically, with a particular process or something that you need to do. And so you have to consider your outside resources. The biggest thing with a crime scene is that once you get there in law enforcement, you can control that scene as long as you need to. There's not anything that legally prohibits you from holding a scene. You may have to get a search warrant or you may have to get, go through some hurdles, but those are easy hurdles to go through. And I have worked crime scenes where we've held a scene for 5 days and potentially longer if you needed to, because once you let it go, it's gone. You have to assume that whatever evidence you wanted is gone, because even if you went back and found it later, the argument is you didn't preserve the scene. How do you know that that's the evidence that was there? So you have to do that step. You have to document all these different things, and if it requires getting outside help, that outside help is available.
And where would that outside help be available if you need it?
Well, the first place that, being a police officer in Florida, the first place that I would look to for outside help would be the Florida Department of Law Enforcement, because they have forensic science laboratories at various different regional laboratories throughout the state. And so they have a lot of different people and provide a lot of different forensic services through their laboratories. If FDLE is not able to provide that service, then your next step would be looking at other law enforcement agencies, perhaps federal, FBI, Bureau of Alcohol, Tobacco, and Firearms and Explosives. They have their own laboratories and their own experts in various things. There could be other ones. And then past that, if you can't find it in a forensic science laboratory, a government laboratory, or law enforcement agency, then you look to private sector people like myself that do stuff. And I actually have done some cases where I've been called by law enforcement and brought in to help them with whatever particular issue that they were dealing with in order for them to figure out what happened and be able to make a decision as to whether or not to arrest somebody.
Would you agree or disagree that if you have the lead detective who is not well-versed in the issue of self-defense, would you agree or disagree? Just speak to the rest of the detectives, right? Find the detective that does have that experience. Is that a difficult thing to do?
No, in most agencies, you got somebody in the agency that's got some background with that. So, yeah, the detective that gets there may not be the one that's got a lot of background in it, but if there's other detectives, and typically when you're at an agency, you already know. I mean, there's people you work with, so you know who it is. That I would get calls because I had kind of had a specialty in shooting reconstructions and stuff, where detectives would come to a scene, there'd be another crime scene investigator there, and the detectives would. Next thing I know, I'm getting a phone call from my supervisor saying, "Hey, the detectives on the scene have asked for you to come out there," because they recognized that I was able to do things that maybe the ones that were out there didn't have as much experience with. So, you could easily, between your own agency and other law enforcement agencies, and then worst case, the private sector could find the assistance that you need.
Let's continue on this road of perception, if we can, for a bit longer. Is the environment of where a shooting takes place, is the environment important, and if so, why?
Well, the main issues that you have with respect to environment, it's always important. There's always going to be something about it that you need to understand. But you need to be able to understand the constraints within a particular environment, meaning what things limit what could have taken place. So, here you're talking about a movie theater and you have people sitting in rows of seats. I mean, we pretty much all, anybody that's been to the movies knows what that's like when you go in and you sit down, and especially if you're not at the end of the row and you're in the middle of the row and you have to go from the end of the row to where your seat is, those kinds of things that create constraints as to what could take place. There's a lot of chairs in the way. You have a very limited space between there. You also, in a movie theater, you have things like a step down from one level to the next level. That's not, normally if you're in a room like this, it's all at the same level. In a movie theater, it's not. So you have to be able to document all those things to know how is that affecting what could happen and what somebody could see or perceive.
Let's talk about some of those issues that in the environment could possibly affect perception. Would you agree or disagree? I think we've talked about lighting. That's an easy one, right?
Right.
And we've talked about noise. That's an easy one. Is that correct?
Yes.
Physical layout. How does physical layout sometimes affect one's perception?
Physical layout really more than anything has to do with, like I said, the constraints, the ability to move, the ability to see what's there and what could, affect how you perceive something, as well as just the general space. How does it affect movement? How does it affect the way somebody can move or react to something that's happening? Things like that.
Now, in this particular case, we had video cameras, surveillance cameras in this theater. is one going to get the same perspective that the accused has if he's sitting in seat 9, back row, as you get from a video camera that's up 30, 35 feet up in the air?
No.
And explain to the ladies and gentlemen of the jury why you don't get the same perspective.
Multiple different reasons. I mean, not the least of which is that the video camera is not really giving you the same perspective. Even if I had a video camera sitting right next to my eye right now, the camera and what people would see watching that video would not be identical to what I see. But the location of it is significant. In fact, one of the training, whenever I teach a shooting reconstruction class, I talk about video quite a bit because, especially nowadays, it shows up so much in the cases that we work. That I have an example case that I use where there's two different in-car, it's a police-involved shooting, there's two different cameras, police cars that have in-car video cameras that record the incident.
Objection relevance to the question that was asked.
It's very, very relevant. He is explaining that process and that problem.
And what happens there in this particular one is one of the reasons why I train on exactly this topic is that the first video camera, you play it, and the way that the shooting looks is it basically looks like a guy's walking away from the police and they shoot him in the back and kill him. And even in a room full of police officers, you play the first one and most of them like, wow, what was that? And then you show them the second car, and in the second car you see the guy pull an object out that looks like a gun, point it at one of the officers, and there's a lot of information that's not captured. So whether you have multiple cameras or even multiple witnesses, wherever I am, I'm seeing something that even somebody that may be close by me doesn't see exactly the same way I saw it. And certainly a camera is the same way. If I've got a camera that's way mounted up on the ceiling over there, it's not seeing this incident the same way my eye sees it at the time.
So what do you do with that? That's a problem. How do you try to compensate for that?
Well, the main thing there is to document as much as possible from the viewpoint of any given person that you're dealing with, whether it's a witness or whether it's the person that's actually involved in a shooting, to get their perspective. So if you have, say, a shooting like this, where you have a person that's in a movie theater seat and shoots somebody, I would want to go back to that movie theater seat and have them show me, just like I would with any of the other witnesses out there, I'd want to bring that person back in, put them back in that movie theater seat, and have them explain everything from that perspective, and then look at it. They say, I saw such and such, okay? Can they see that from their positioning? What kind of lighting? And you can go through really in detail with them. What was the lighting like at that point? What could you see? And get the details of it and then document that the best that you can with photography and the video if possible, and those kinds of things to be able to know and one, keep a record of it, but also to sort of test the veracity of what you're being told.
And if you're in a theater like the Cobb Theater, and would you have the ability to go to management and say, I want you to turn that lighting to mid 1?
Certainly. I mean, as long as that the movie theater's cooperative, which in this case it was, then you could simply ask the management I myself went to the movie theater and did exactly that and said, show me the lighting level. And they explain the different lighting levels, and they set the different lighting and things like that. And of course, if you needed them to replay whatever was on the screen, things like that, just ask them to do it and see what what you're able to document and do with that.
And if they refuse, you have subpoena power and you have search warrant power, right?
That's right. Investigative subpoena, which basically, as a detective, all you got to do is go to the state attorney's office and ask them to prepare an investigative subpoena. And then you can also, if necessary, get a search warrant. draw up a search warrant, take it to the judge, have it signed, and then and at that point the theater doesn't have a choice.
Dr. Knox, in a situation like that happening in the theater, would you yourself, as the crime scene investigator, would you sit in that theater and have the lights dim to mid-level 1 and have the previews played?
Objection relevance.
I'll overrule.
Would you?
I would, yes. I would routinely in shootings look at those kind of things, and in fact I even teach it when I teach a shooting reconstruction class and talk about documenting lighting conditions and things like that.
Why would you sit yourself there and have those parameters for you? Why would you do that? Why is it important?
Well, several things. Part of it is that you're documenting because you don't know what questions are going to come up later on. You don't know what issue may arise later on as you go through an investigation, so you want to document what's there. But also, more than that, is because here's a scene where you're trying to reconstruct what happened, that's sort of at the center of reconstructing it, is knowing what are the conditions, everything in terms of the conditions at the time that would affect what a person saw and perceived and what they're responding to.
In you mentioned bringing the accused to sit there in the seat. And, what sort of information would you want from the accused in your questioning of the accused in order to give you a good perspective over what the accused was possibly seeing and knowing at the time?
Well, you really want to understand, with whether it's the person that's the shooter or any person, the witness or anybody, you want to know what it is that they say that they saw, and you want to test it. Because obviously if something that a person is telling you is inaccurate, particularly if they're the person involved in the shooting, you want to confront them with the fact that it's inaccurate. So you might find something that as you bring them in, you test it, and they've described something, and then you realize that's not possible. So then you would confront them with, well, that's not possible. So, explain to me why you say this, but this couldn't have happened. Because one, you're giving them the opportunity to correct if there's something wrong in their recollection, or you're trying to see what a person may be doing. So if a person's being deceptive, for example, you keep testing them on those things, and then you just find that they keep changing their story, and that would tend to lead you to, think that maybe they're not being truthful. So it's not just about coming in and then just taking what somebody says at face value. It's about testing what they say to make sure that it's true and accurate and it's correct.
Obviously, you have participated in police-involved shootings in the past. Is it important to know, in a police officer shooting, for example, the body of knowledge that the police officer has?
Yes.
Yeah, I'm going to object to that. May we approach?
Yes, you can approach.
to the crime scene investigator. It's a self-defense case. And you know that the person that's accused is a retired police officer. Would you want to know the body of knowledge that that police officer, former police officer, had in threat assessment and realizing the cues of danger? Would you want to know that if you were the crime scene investigator and the lead detective?
You would. Primary reason is just that you understand from a person's training and background things like their knowledge and ability to handle a gun, how would they handle it. So if you've been through training, for example, law enforcement training, then there's certain ways that you shoot a gun that you're trained to do that somebody who's never had that training would not necessarily inherently do. But also you want to look at what it is that he's looking at and what he's aware of in terms of cues and indicators to him that may have led to the decision to fire. So as a crime scene investigator, I'm primarily looking at trying to identify those things and then figure out, what is it that he saw? And that's going to be within the framework of his knowledge and training, not just that he saw something, because what does it mean to him? And so then you know better how to document that. So what do I do to document that so that it shows what he's perceiving and whether or not what he's describing to me matches up with what he's saying. So again, it's a matter of let's figure out what he made his decision on, and then we need to document all those factors to the best of our ability to be able to show that, if there's a particular decision that he made, was it made on, was that a reasonable conclusion from his
Your Honor, I
point?
object.
So let's continue with this perception factors that we talked about. I think we left off with physical layout. Video surveillance, we talked a little bit about that, did we not?
We didn't.
Okay. And so how important is it to a crime scene detective or crime scene investigator to realize, first of all, whether there's video around?
Video is,
I'd object only because I thought this was asked and answered. We went through a video already, but I don't know more. But
All right, to the extent that it's been asked and answered, sustained.
video is important to document it, to be aware of as a crime scene detective, because one, it can potentially show you very important evidence. One of the biggest things we get out of video in terms of reconstructing, particularly in a shooting, is timeline. Because when witnesses are telling you about something, you don't really know exactly how fast it happened. You just know what their approximation. So if you ask somebody, well, you know, you heard this and then a shot is fired, how long in between those things, they're giving you an estimate. But with video, you can often go to it and know exactly between an event to another event. Sometimes we get video when you have multiple shots fired. We can know exactly the cadence and the speed with which those shots are fired because of what's recorded on the video or audio. So you need to look at it. You need to know and be aware of it, because until you know it, until you've seen it, until you've had a chance to really analyze it and look at it, you have no idea what it's going to tell you.
And so, if you go into a theater and you see that there's a surveillance system, you just tell yourself as a crime scene investigator, I'll see it tomorrow or the next day.
No, it could, because like any other type of evidence, you need to secure it.
Immediately?
You need to secure it immediately, because you need to make sure as fast as you can that just like any other evidence, that nothing's going to happen to it. And then you also need to see it as soon as you can, because that can affect how you process a crime scene, what evidence you're collecting, because you may see things on the video and realize, oh wait, that's involved, or I need to look at this item, I need to look at this location, I need to do things because you just saw it on the video. And so it was not uncommon for me, even in smaller things. I'd go to a burglary scene or go to a robbery scene and see that they have a surveillance video, and I'd ask them, can I see that video? Because if you had, say, an armed robbery, it was an excellent tool for me as a crime scene investigator to watch it happen on the video, so I could say, okay, well, the person went over here and touched this, and they went over here and touched that, and now I know areas to process, and I know what kind of things to do.
And so, tell me, what if the company says, you're not getting it?
Well, the first thing is secure it, because you don't want them to be able to do anything with it. And then go get a search warrant. And then once you have a search warrant, they can tell you you're not getting it all day long, but they don't have a choice. That's signed by a judge. It's an order for you to go get the evidence. And so that would be the step that you would take. You would not let that just go and then rely on somebody else to provide it, because you don't know what they're going to give you and what's been contaminated in the process.
So law enforcement controls the process of securing it?
Absolutely. Once you're there at the scene, then you take control of all of it.
Would you allow an entity just to kind of help you out to preserve it?
You wouldn't. I mean, obviously there's going to be probably some level of assistance, even if it's just, can you show me where the DVRs are? Have them take you to the room, those kind of things. But you're not going to let them take care of it and just trust that they'll provide you with the video, not just because of a fear that they may do something to it and contaminate it, or that they may not cooperate with you, but more than that is that you don't know what level of training they have in handling that type of evidence as a forensic matter, and they may do something inadvertently to contaminate that evidence that you now have to deal with. And so that could be problematic. You need to secure that as fast as you can.
Do these departments, for example, the Pasco Sheriff's Office, do they have cybercrime units that are competent individuals in order to properly preserve video evidence?
Most reasonable-sized law enforcement agencies have at least somebody within usually in their detective unit or technical support unit, that's able to do that. And if the agency itself doesn't, Florida Department of Law Enforcement does, and it's just a phone call away.
What about seating? Not only the seat that the accused person was sitting in, but seating in general. Is that an important factor to consider?
Yes. Whenever you have a case like this where a person is seated and they're dealing with a person is on another seat in front of them, you have introduced, as I was describing before, constraints. You have stuff in the way between the two people, and also obviously things change. Perspective changes. All sorts of things change based on if I'm sitting down as opposed to standing up.
So what do you do with those seats? Do you measure them?
Yes.
Do you examine them to see what type of seat it is, whether it's a very deep cushion or firm?
Yes.
Do you measure the distance between the seats?
Yes.
Do you measure the height of the seat?
Yes.
Do you measure the height of the back of the seat?
Yes.
Do you measure diagonally as well, if need be?
If need be, yes.
And while you're doing those measurements, what do you do in order to memorialize what you're doing?
Well, you can do several different ways to keep track of that. You could draw sketches or diagrams and diagram and show all the different measurements that you collected. You can photograph them. You can put a measuring device down and then take pictures of each measurement to be able to show it. So there's several different ways you could do that.
And the reason that you're preserving all those measurements is for what reason?
Well, primarily because from a standpoint of reconstructing, you need to have the measurements of the area so that you know what kind of distances you're talking about. But also, in the initial portions of it, you're just documenting everything to have it documented so that you know the locations, distances, and all those sorts of things, because a question may come up later on during an investigation, and you don't want to have to go back and try to get those measurements.
Mr. Escobar,
Yes, Your Honor.
we need to take a lunch break.
Okay.
So, ladies and gentlemen, we're going to take an hour for lunch. If you would be back at 2 o'clock at the jury pool room. Please remember my instructions during the recess. Don't do any independent research. Don't talk about the facts of the case amongst yourselves or with anyone else. Don't watch any news. Thank you. Enjoy your lunch.
I'll ask for the recess in 1 hour.
Do we have our jurors all?
I think we do.
Okay, good. We ready? Yeah. Bring them in, Tina. Thanks.
Hey, are you ready?
Thanks, Terry.
Ready for the jury, Your Honor?
Yep.
Jurors into the courtroom. Jurors may be seated. President accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, thank you for returning. Were you all able to abide by my instructions during the recess? All right, good. We'll get started again. Dr. Knox, you're still under oath. Go ahead, Mr. Escobar.
Dr. Knox, I think we left out where we were talking about some of the things that you do as a crime scene investigator involving cases, specifically also in self-defense cases. What about the distance between the shooter and the deceased? Is that an important factor? And if it is, why is that an important factor?
Well, it's definitely an important factor because obviously the proximity of two people together goes to things like what they would perceive in terms of level of threat, what kind of interaction they could have, whether or not a person is within range of being struck or things like that. So that would be an important thing to document.
And so what do you do in that circumstance to memorialize that distance?
Well, the location itself you would look at so that you could document, for example, here you have seating which affects distance. Then, of course, you also could have things like if there's any physical evidence that would point to where people were located, documenting that and measuring those distances and looking at any other evidence, whether it be video, whether it be autopsy results, anything like that might also help you to know what kind of distances there might be between people.
What about the relative physical size of the two individuals? How do you memorialize that?
By taking actual measurements. So in the case of a person that's deceased, they get measured at the time of autopsy. In the case of anybody that's living, you can go measure them. So it's not uncommon in a shooting case, for example, to take the person that fired the shot and then get some measurements of their body in order to have those measurements to know things like how far out could they have extended their arm and what kind of reach, how high they would be sitting, those kind of things.
Getting back just briefly to the issue of interviews, and in reference to the location of witnesses and the accused and the deceased, how intent are you in trying to make that determination as far as distance is concerned? How important is it to try to be as exact as possible?
I object to the relevance of how important it is to this witness.
In crime scene investigations altogether.
All right, with that clarification, sustained, and we need that clarification. Thank you.
So that's one of the things that you are really focused on when you're doing crime scene investigations and reconstruction with respect to a shooting, is because obviously the distance between two people is very significant as far as what they could do to one another, as far as, what the person would see and perceive, those sorts of things.
Your Honor, we would tender him now before we start getting into what work he actually did in this case as an expert witness in the field of crime scene investigations and reconstruction.
I would object to the format of the questions.
Approach. As to the crime scene reconstruction
An investigation.
and investigation.
Matt, thumb drive, real quick. May I approach, Your Honor?
You may.
Dr. Knox, I'm going to show you what's been marked as defense exhibit number VV and ask you if you recognize that exhibit.
I do.
And what is that an exhibit of?
This is a PowerPoint presentation that I've prepared in this case.
And does it include photos that you took and photos that you've also analyzed in this particular case?
Yes.
And do they fairly and accurately depict those photos that you considered in your work in this case?
Yes.
Your Honor, we would, at this point, as a demonstrative evidence, ask to publish the...
Renew prior objections.
Yes, I do, Your Honor. I'll prior again. Sorry.
All right. It's the same ruling system, but,
Yes, Your Honor. Okay, let's go to the next screen, please. Mr. Knox, if you... Your Honor, may I ask Mr. Knox to step down, please? Mr. Knox, I'll give this to you. If at any point in time you want to point something out or it's available to you. What is this particular photo in your PowerPoint? And I believe it looks like it's there's a little number 3 down here. I'm not sure if that stands for it or not. But what is that photo that we're seeing?
So this is an overall photograph just showing the outside of the movie theater, just for reference purposes, that this is where we are at this particular scene.
Okay, next, man. And is this showing the Theater 10 lone survivor area of the entrance of the theater?
Yes, so you can see there are multiple theaters with different signs. Number 10 is right here, kind of in the middle of the photograph.
Next one, man. And this photo right here, did you take this photo or was this a photo that was provided to you?
I believe this is one that I took.
Okay. And so let's talk a little bit about you going to the Cobb Theater. How many occasions did you go to the Cobb Theater?
Twice.
Okay. And let's talk about the first instance that you went to the Cobb Theater. What was your purpose in going to the Cobb Theater during the first instance?
So the first time that I went to the Comp Theater was to see it, to get photographs and measurements and things like that, as well as I had the management show me the different lighting levels and stuff so that I could become familiar with those things.
Okay. And so this is a photo that you took there?
Yes.
I think you took something like, I think it was over 200 photos. I'm not going to go through all of them. Don't worry about it. We're only going to go through a few. What is this particular photo showing?
So you can see this is sort of a wide angle showing most of the theater with the house lights on. And then this yellow circled area here is just showing the area where the actual shooting took place.
Next one, Matt. Okay. What is this particular photo showing?
So this one, and you can see that there are annotations showing the actual seats where Mr. Oulson and Mr. Reeves had been sitting.
Now, as part of your investigation in this case, did you get a large volume of documents that our office provided you? Police reports, for example?
Yes.
Depositions, for example?
Yes.
Lab reports, for example?
Yes.
Forensics, for example?
Yes.
Okay, so you had a large volume of information that was being provided to you even before you went to the Cobb Theater.
That's right.
And did you analyze all of those documents in an effort to be able to do what you were asked to do in this particular case?
Yes.
Okay. Go ahead, ma'am. And so this is a picture that you did not take, obviously.
Right.
Tell me how you used this particular photo and why this particular photo was of interest to you.
Well, this shows the area. This is one of the actual ones taken by the forensic investigators with physical evidence still in place. And this particular photo is a good view looking down because you can see the two rows of seats and see where the things are on the floor and around the area.
Okay, next. So, in your measurement process, let's go back to that last one so that he can talk a little bit. In your measurement process, what is it that you wanted to do? Show the ladies and gentlemen of the jury what was important to you to document, to measure for your assistance in this case.
Well, the main thing is just to have measurements of the different dimensions of the seat. So things like the seat bottom, where is it when it's pushed down and somebody's sitting in it, how high is it, what's the width between the arms, and what's the distance between this seat and the seat in front of it, those sorts of things.
Okay, Matt, next one. And so you go about doing that, is that correct?
That's correct, yes.
Okay, and as you're taking these measurements, how are you memorializing it?
So you can see here that what I'm actually using is a tape measure that has large numbers on it, show up in the photograph. And so these measurements are all photographed, and then what I've done is added annotations so that you can see what that actual measurement is.
Before you use those measurements, do you take any precautions to make sure that the tools that you're using are forensically correct?
Yes, yes. So this particular tape measure that you see here, this is actually, it's what's called a pocket rod, but it's sold by forensic supply places as well as places that sell surveying equipment, things like that.
Okay. And so tell the ladies and gentlemen of the jury what measurement you're seeing here at 1 foot 7 inches.
So this would be the measurement just with the seats in place, nobody in them, from the basically the end of the armrest on the back row of seats to the back of the seat in front of it.
Okay. Next one, Matt. Okay. This is a little different. Tell the ladies and gentlemen of the jury what measures 1 foot 3 inches.
So you can actually see here that this seat back has some recline to it. So when a person's sitting in it, it actually can push the seat back a little bit. So what we did is pushed it back as far as it would go, and then did the measurement again, and it reduces to 1 foot 3 inches.
Okay. And so you're doing the variables for preservation of evidence. Is that what you're doing by pushing that seat back?
Yes.
Okay. At the time of this incident, you don't know if the seat was back or if the seat was not back. Am I correct?
That's correct.
But you're providing those variables for someone like myself to understand.
That's right.
Okay. Next one, Matt. What's this measurement?
Here, this is a diagonal measurement from the top of the seat in the back row to the top of the seat in front of it. Again, seat just in the static position, not pushed back. So this particular diagonal is.
Oh, you want to just have to go here. It's red. You should be able to.
Yeah. So this particular one, you can see the measurement goes, it's 3 feet 8 inches, so measuring diagonally from here to here. And what that's basically doing is showing you how much distance you have moving from the back of the seat at the top of the seat over to here along that diagonal.
Next one, Matt.
And then this is a similar measurement, except instead of measuring at the top of the seat, measuring to the back of the seat. And you can see it's a little bit shorter distance, but it measures 3 feet 2.5 inches from here to this top edge of the seat.
Okay, go ahead, Matt. Okay.
And then here measuring the from the back of the seat on the seat itself straight across to the back of the seat in front of it. And of course I've included a measurement here, so 1 foot 5.5 inches, 5.5 inches from the back of the seat to the front edge of the seat, and then 1 foot 3.5 inches from the edge of this seat to the back of that seat, and then the total distance from here to here being 2 feet 9 inches.
And is this something, this is a procedure that you would do in every crime scene investigation that you would perform? Is that correct?
Right. You take measurements of whatever's around there. So sometimes you're working a scene and it's in a bedroom, so you're measuring where all the furniture is and things like that. Here, because it's the movie theater and the seats or what are of interest.
Is this the same process that you teach your students as well?
Yes.
And law enforcement throughout the country?
Yes.
Okay. Next, Matt.
And this is showing the width of the seat at the top of the seat back. It's 1 foot 8 inches.
Next one, Matt.
And then this is showing the distance between the armrests on the seat, which is 1 foot 10 inches.
Why is that particular measurement of importance, the width of the seat?
To show how much room a person is sitting in the seat has to move around. So how far can you move from one side or the other?
Next one, Matt.
And then here, this is showing a height measurement. So coming up from the floor to the top of the armrest, right here at the front of it, at the cup holder, just slightly over 2 feet, 2 feet 1/2 inch.
Next one, Matt.
And then this is showing going from the floor to the seat bottom where you would be sitting on it. And you'll notice there's a hand here. Somebody's actually pushing the seat down because, again, just like the seats that recline back, the seat does go up. And so we want to make sure it's pushed down the way it would be loaded if somebody was sitting in it.
Next one, Matt.
Okay, and so this is showing the distance here between this seat bottom and the top of the armrest, which is 8.5 inches.
Okay, Matt.
And then this is just showing some measurements showing the height of the wall here. So this wall, this tape measure behind her is actually on the floor, and you can see that this wall behind that seat is just over 5 feet.
Okay. That's your close-up.
That's the close-up that actually shows you the measurement, 5 feet 2 inches.
Okay. Next one, Matt. Okay. Let's stop there for a second. You took far more measurements than what we've showed here today. Is that correct?
That's true.
Okay. You took measurements throughout that particular theater. Is that correct? At the different locations throughout the theater.
I did. I took quite a few different measurements.
Okay. Now, Matt, let's go to the next one. The documentation of items there at the theater at the time of the shooting, is that an important thing to do?
Yes.
Okay. And now that you've taken measurements of certain areas, are you able to certainly understand a bit better where those particular items may have been, as far as distance is concerned?
Yes.
Okay. And so what do we have here in this particular photo?
So this is just showing, again, going back to that overhead looking down on it, this is the evidence, the way it was documented by the forensic investigators, but you can see where there's a popcorn bag on the floor here, and there's popcorn, and this is the seat that Mr. Reeves was sitting in, so this would be right, basically between his feet, and then this would be off by his right foot.
Okay. Next one. And that's documenting.
That there's a cell phone right here on the floor.
Okay. Same documentation?
Just a different vantage point with the camera, but yes.
Now, what does this photo, what is that depicting?
This is all showing the same area, just a different angle, and I point out that the fired cartridge case from the pistol is documented right here.
Now, this photo was taken by their forensics, is that correct?
That's right.
And some of these identification marks are, that one's hard to read, it looks like. Is that depicting the actual seat, number and row?
Yes, that's the way I understand it.
Okay. And so, if I can read it clearly, this would be the seat that Mr. Reeves, according to their depiction, that Mr. Reeves would have been seated. Is that correct?
That's right.
Next, Matt. I think there's a better one. I may be wrong. There was a fired cartridge case that was found in this case.
Yes.
Was that the general location of where it was found?
Yes.
And Matt, could you give us the next one? I believe it's a easier picture to see. Is that a photo depicting the cartridge of the bullet, or spent casing, I should say, not cartridge? Goes to show you how much. Casing of the bullet, that's where it was, right?
That's right.
Okay. Next one, ma'am. Before we get to the next series, did you also see the autopsy photos and the wounds of Mr. Oulson?
Yes.
Okay, and did you also see the wounds of Mrs. Oulson?
Yes.
Okay. I don't think we need to go through those. Let's go through the next series. Okay, so now let's talk a little bit about, and I want you to stay standing here before we ask you a series of questions on this. Describe to the ladies and gentlemen of the jury what...
I object.
Okay, so let's talk a little bit about backlighting and explain to the ladies and gentlemen of the jury what backlighting is.
So backlighting is basically like the name implies, backlighting being lighted from the back. So, if you, most of us probably taken a picture of somebody outside with the sun, there's a bright sky is behind them, and you take the picture, and then you look at it and you see nice bright sky, and the front of them is dark, and it looks more like a silhouette. So that's an example of backlighting. And so, what we're interested in any kind of crime scene is just what sort of lighting conditions could be there and what sort of backlighting might be present that could affect how somebody sees it.
And so we're going to go through a set of photos here. You are not telling this jury by any stretch of the imagination that what they're seeing here in this backlighting is what Mr. Reeves actually saw on the day of the incident. Is that correct?
That is absolutely correct.
You're trying to show the actual effect of backlighting in certain positions when someone is in front of that backlight.
That's correct.
Okay.
Counsel, just over to the side.
Okay. Mr. Knox, just hold a second. Court's going to be reading an instruction that's appropriate during this period.
Ladies and gentlemen, this testimony is being offered only to demonstrate the concept of backlighting, and that's what you're to consider it for.
So let's talk a little bit about how you set these photos up in order to show the backlighting effect. This individual that we have here, what is that?
So that is it's a forensic mannequin.
And you use that mannequin and you place that mannequin where?
So the mannequin is placed on not the back row, the row in front, standing in front of the seats facing back toward the back row.
Okay. And at the time of placing the mannequin there, did you have a camera?
Yes.
Okay. And at the time of placing the mannequin there, was there backlighting, and where was the backlighting coming from?
The backlighting, as you can see, this is actually coming from the movie screen right there.
Okay, and so you place the mannequin in various positions in order to do what?
To show the effects of that lighting. So,
Objector on?
Okay, Dr. Knox, we're going to be going now through a series of photos of the mannequins in different positions. Is that correct?
That's correct.
Okay, go ahead, Matt. Go ahead, Matt. Go ahead, Matt. That's it. Okay. You can take your seat. Sorry, Your Honor. I made you come all the way over here, but just... Dr. Knox, you agree or disagree that I presented you with an issue concerning two items in this case, one being a light that was either reflective or emanating, and there were two items that I wanted you to consider in telling me what that light source was, correct?
That's correct.
Remember that? That was in the video.
Yes.
Is that correct?
That's correct.
Yes.
Dr. Knox, back to the reflective or illuminating source. And you you remember taking Mr. Reeves' shoes that we had obtained from court order?
Yes.
And you remember taking an iPhone?
Yes.
Apple iPhone. And you remember going to the theater at, you agree or disagree, what, 2 o'clock, 3 o'clock in the morning that we went there?
It was about that, that's right.
And did we bring Mr. Koenig and Doug Lacey from Beck Tech with us?
Yes.
And you agree or disagree, we did that in order to try to replicate and find out what the source of that illuminating or reflective light was that we see in the video?
That's correct.
And you agree or disagree, when we went there, the entire system had been changed?
That was my understanding, that's correct.
And you agree or disagree that we could not perform that analysis because of that reason?
That is correct, yes.
I have no further questions.
Thank you. Cross,
Thank you, Your Honor.
are we using the screen anymore?
I can move it.
That'd be great. Thanks.
Can we move it?
Yeah.
Good afternoon.
Good afternoon.
I'm assuming you were billing in this case.
Yes.
Okay, and what's your hourly rate?
For this case, I think it's at $250 an hour.
Okay, and you charge for travel?
I do, yes.
And how much on top of the 250 do you charge for travel?
Well, the travel I charge at half rate, so for actual travel time.
So 250 an hour, and then for each hour that you travel, $125?
That's correct.
All right. And how much have you billed so far on this case?
I really don't know the numbers for that. I mean, I've obviously done a fair bit of work, but I don't know what the numbers are.
Okay. You keep records of that, I'd imagine?
I do.
All right. And you've testified, I think you said, in other cases?
Yes.
Okay.
Yes.
And I would imagine that when you testify in other cases, one of the first questions the opposing counsel asks you is how much you've billed in the case, right?
Sometimes I get asked that.
Okay. Well, wouldn't you say it's a great majority of cases? Because that's something that people normally bring out with the opposing people that are testifying for the other side, right?
Sometimes yes, sometimes no.
Okay. Well, my question to you is, don't you think it's a majority of the time?
I don't know. I mean, I've never really thought about it, but
I mean, for almost every deposition you've taken, people ask you, right?
no, I mean, not always. No, I get quite a few cases that's not really the.
Right. I'm not asking you about all the time. I'm just saying most of the time.
Yeah, I mean, I don't know. I couldn't give you the numbers. I don't know if it's most of the time, half the time, or what.
Okay, we're going to move on. The only reason I'm asking you is I would think that you would anticipate that question would be asked of you today so that you could come to court prepared to answer that question.
Yeah, I don't really look at the money numbers much at all.
And he doesn't object because he could have subpoenaed Justice Tico if he wanted that question asked. He's giving some indication that there's something wrong with it.
I'd object to the speaking
All right,
objection.
Overruled. Move on.
The measurements that you testified to that we saw up on the screen, those are just basically measurements. You're not presenting them to this jury saying that these were where people were at any particular time, correct? They're measurements of the seats.
Right, measurements of the seats just showing the different variances and so forth. Yeah.
Okay, so like what I was saying, it's supposed to give this jury the impression that's where anyone was in any particular point in time.
That is correct. You're correct.
Let's just talk just a little bit about backlighting. Now, just to make sure this jury understands, because this is important, the presentation that we all just watched, the only purpose of that was just to demonstrate the concept of backlighting.
That is correct. To demonstrate the concept, I'm not trying to demonstrate that that's what anybody saw at that theater that night.
Okay, and the object you chose was mannequins, because I guess it made sense, but in reality you could have chose any object to demonstrate what the backlighting was?
Yes, I mean, I use mannequins because you have at least a human-like figure, because some of the issues with lighting is things like shadow. And so
Right.
obviously the shape of your face may cast shadow differently than another object might.
And again, we weren't using those mannequins to say that was Chad's shadow or anything at all like that, right?
That's correct. That's correct.
And when you say backlighting, like in the photo that you showed to the jury, there was a white background, correct?
That's right.
All right. And you're not telling this jury that that was the background that was going on at the time of the shooting, right?
That's correct.
All right.
That's correct.
So really that picture doesn't depict what was going on at the time of the shooting, like you already indicated.
Right, right.
And when you talk about backlighting, obviously the nature of that is it's the back, right? I mean,
Right,
you saw the screen in the background is what I'm getting at.
Right.
Now that doesn't account for the overhead lights that were on, correct?
Well, when those pictures were taken, the lights were set at mid-1, which is the setting that they would have been at the time of the actual shooting.
Okay. And there was also the screen though itself would be moving and having a different light form.
Right, right. What was played at that time was just, it was a different trailer. It's not the same trailer, so I don't know that exactly what was on the screen at the moment of the actual shooting.
Okay. And you would agree with me that the camera lens cannot adequately represent what the human eye sees.
Yeah, that's correct, because for one thing, it's a two-dimensional image as opposed to the three-dimensional that you'd see, but you're correct. It is a picture of it, not what your eye actually sees.
Right. If there's no technology out there in reality, there may be in the future probably, but as of right now, there's no technology that can replicate what the human eye sees.
That's correct.
All right.
That's correct.
So we're just looking at a picture that's demonstrating some light in the background that wasn't the movie at that time, correct?
That's right.
May I have a moment, John?
You may.
Nothing further. Thank you.
All right, thank you.
Any redirect?
Not necessary, Your Honor.
All right, thank you. May this witness be released or
Yes.
on standby?
Stand by.
All right, Dr. Knox, you're free to go, but if you get called back, you have to come back. I'm sure they'll allow you plenty of advance notice if need be. Thank you, sir.
Thank you.
Who's next?
Your Honor, before we call the next witness, we have some legal housekeeping matters regarding the next witness.
Okay. Will 10 minutes do it?
I think so.
I hope so. Ladies and gentlemen, I'm going to let you take a short recess. Please remember my instructions during the recess, and we'll call you back pretty quickly. Thank you. Okay, so what do we got? Stuff on Dr. Bedard?
Yes, judges. The next witness is Dr. Bedard. I know that certainly we had a Daubert hearing. The ruling was that he could testify.
Speak up a little.
Yeah.
We had a Daubert ruling. Certainly the ruling was that Mr. Bedard, Dr. Bedard, would be able to testify as to his expertise in the field of defense tactics, use of force, and human factors. And I know the order says something to the effect of subject to the normal rules of evidence, so I know that state approached me with some concerns. One of the concerns was because, you know, the deposition.
Let's be quiet in the galley, please. We're trying to hear.
The deposition was very wide-ranging, and I understand Mr. Martin's perspective. Dr. Bedard didn't write a report, so he just wanted to find out what his knowledge of is, and then potentially what he would be testifying to. And so one of the issues was a kind of a narration of the video. We agree that Dr. Bedard is not going to narrate the video in any form.
Okay.
Another issue, as I understand it, was that there was some discussion as to whether Dr. Bedard thought that Curtis Reeves acted reasonably. He gave his opinion because he was asked. I think he prefaced it with something to the effect of, I can't say that in front of a jury. Certainly, that's not going to be brought out in his testimony. One of the issues is I think it's an objection as to cumulativeness, because we had Dr. Cohen testify as to age-related kind of self-efficacy. You know, a person realizes they're vulnerable and all that. And so I know that that's something that one of the things Mr. Martin wants to address. So the court knows what my perspective is. It's true Dr. Cohen did testify to a limited degree about a perception of vulnerability. However, we stopped short of allowing her to do a threat assessment. In fact, that was one of the things that was objected to. So when it came down to making certain choices of doing things because of that perception of vulnerability, she wasn't allowed to do that. So it's not cumulative in that Dr. Bedard is going to testify that that's a factor in terms of threat assessment and risk assessment, which Dr. Cohen was not able to testify to.
Okay.
Judge Lewis's order, as you know, indicates as to whether any specific facts or data underlying Dr. Bedard's opinion or any specific testimony will be admissible at the trial will be a decision for the court at the time of trial and subject to any objections on that ground. So I have numerous objections to numerous parts of his testimony, and it includes not only what I presented in my previous motions that have been thoroughly briefed and you've had a benefit to read, but also statements that he made in the very lengthy deposition. So I'm going to begin with the issues that I brought forth in the motions that I filed.
Okay.
And if we could just be able to address one at a time.
Yes, one at a time.
Mr. Martin has,
Yes.
looks like many.
Yeah. Okay. One at a time.
Judge, one of the things that has always been a concern is the use of the video by experts. When an expert testifies, even though there's a jury instruction regarding the jury can accept or reject any testimony, including the expert, anytime a person comes in and says, I know more than you because I have specialized knowledge, it carries some weight, and some people go, okay, I give up, I'm just going to go with he says. So it's important that I ferret out exactly where we're going with the expert testimony. I'm going to deal with the use of the video to start with. I understand that there's not going to be a running narrative of the video. But this is how the video was used by Dr. Bedard. He used the video to he used the content of the video in making certain interpretations. One, he used the video solely for his conclusions regarding certain points of interest. You might recall I listed out about 6 points of interest, and they included whether or not Mr. Reeves was hit with an object before the tossing of the popcorn, the relationship between the parties, the number of attacks, whether or not Mrs. Oulson was holding him back, was Mr. Oulson leaning or standing over, and whether or not Mr. Reeves uttered the words, throw popcorn. All of those points of interest were his analysis of that was solely based on the video. So when we start talking about, well, I determined this or I determined that, he could be interpreting the video. and there's no way around it. So my objection is that those points of interest, that's for the jury to decide based on the video. He can't come in and say, okay, my review of the video, Mrs. Oulson was or was not holding her husband back. See what I'm saying? So if he comes in and goes through those points of interest, relying solely on the video, well, that's for the jury to make the interpretation, not for the expert. You can understand the weight that would carry, and that's the problem that we have. So that was the thing with the video, not the running narrative. But if that in fact is proper, or he does that analysis based solely on the video, then that's for their determination.
And that's not a problem, Your Honor. Our intent is not to have Dr. Bedard comment on what he saw in the video or make any kind of conclusion, base any kind of conclusion based on the video except for one. The only issue is going to be there is he's going to testify as to perception reaction time. And so the issue is going to be just the timing of the video. And I spoke to Mr. Martin. He's not opposed to this. The question will be not did he watch how long and all this stuff. I can give him time references and say between this time and this time was the firing of the firearm in response to the throwing of popcorn. And I think that Mr. Martin agreed with me on that yesterday. And that's the extent of his use of the video in terms of being able to testify to that. And that's all we're looking to use it for. Not that, I saw, from my view, I saw Mr. Oulson coming across the seat at 13:25:36. That we've shown that video. Mm-hmm. We put photographs in. And the court has seen it as well. The first attack. He's not going to say there were two attacks and all that. If he's pushed, if somebody's going to ask him, well, how did you come up with this or that? Then they're opening the door for him to say that. But I'm not eliciting that. That's not my purpose in having him testify.
What about that portion? I remember that portion pretty clearly, that, the breakdown of how many seconds it takes to do this, or milliseconds. And,
Yeah, we've had that testimony.
not here in the trial yet, have we? Where was I if that...
No, we have not. And so to keep him from going as...
That witness did it last time. Yeah, at the previous hearing. You're right.
Oh,
You're
okay.
Right. It wasn't off.
Okay.
You're right.
in terms of having...
Look, that concluded, I can handle that on cross.
Okay, so that part is okay. The frames from the popcorn toss to the shoot is what he's going to talk about, the timing.
The whole grabbing, all that.
Right.
And Mr. Martin has agreed that I can lead him to get him through that, so that we're giving him points of reference.
Okay, so
he
we don't
doesn't
go
run
beyond
astray
that.
of
Okay,
That's
okay.
all we're looking to do.
Right.
Okay, so that one's all right. So Dr. Bedard is not going to interpret the video.
But it's not going to be like one of those civil police shooting cases where he's going to say, I looked at the video and I saw this force being applied, or that sort of thing that you typically see in civil cases. That's
Right,
not what
I've read some of his...
And frankly, if you ask him the question, he would refuse to do it because he understands it's the province of the jury. So he's not going to do
Okay, go ahead.
The other issue was that based on his examination of the video, there's missing frames. There is no expertise on that. We've already had the testimony of experts, and so even if you would agree that he has the expertise to make that determination, it's cumulative. So I would object to that, and that was in his second deposition.
What about that?
Well, because I think the context of that again was, you have one attack 12 seconds before the popcorn attack, or what turns out to be a popcorn attack. And so, his hypothesis was potentially, well, I don't know what's happening there. Maybe the camera's not capturing something, but we know that maybe it is or maybe it isn't, because I heard that testimony. He's not going to testify in terms of what if that could be happening and this could be happening. You know what I mean? So the only time that would come up, the state asked him, well, you see nothing happening before that. It's just a popcorn. How can, they're not going to ask that question. So I'm not, I know. So I'm not going to ask him, about missing frames. We've seen that there are parts of what happened missing because of the the inadequacies and the temperament of the cameras and how they were set.
Okay,
So that's not a problem.
all
He
right.
also indicated in his second deposition that he has watched the video, and his interpretation of the video would be most consistent with what story Reeves has been telling. So to compare that to his statement in any way.
Right, I remember that.
That's not a problem. He answered the question that he was asked. It was elicited of him. And again, I'm not faulting the prosecutor. He's, in his words, bobbing for apples. I get all that, but that's not the intention. That's not proper. Dr. Bedard isn't going to testify to that. And again, because of his integrity, he wouldn't if you wanted him to.
Okay,
So that's not coming in.
all right, so that's not coming in.
He also speculated and interpreted what he did not see in the depot. And as an example, in the first, following the first deposition, I learned that there's a lot we can't see, so it's hard to validate what Mr. Reeves says or invalidate it. He also says Oulson standing up and striking Reeves with something, perhaps a fist with a phone. We can't see any of that. And then at the previous hearing, Reeves testified to a segment of what I've heard. He says, I don't see that. So when we're looking at what Mr. Reeves said previously at previous hearings, and then on the video, he's commenting, interpreting, and either giving credibility or not credibility. So that's just improper for him to interpret the video and then say, well, I can either confirm or deny Mr. Reeves' statement. So I object to that.
And again, Judge,
He did a lot of that, as I recall. That was his method of validating things and,
Yeah, the null hypothesis.
Thank you.
Because those questions were asked of him. I know you read maybe the whole.
I
there were
did.
hours and hours of deposition.
I did. I read
And-
hours and hours of stuff.
I know, and so Mr. Martin is very good at asking questions. There's various ways of asking the questions. So it became a philosophy, almost a philosophical discussion between Dr. Bedard and Mr. Martin. And so he said those things, but again, it's not our intent to present him to say that he finds Curtis Reeves credible, or that he finds him credible because he can see it on the video. I mean, that's
Okay.
that's obviously not for him to testify to. That's for the jury to look at and decide. So
All right,
he's not going to do that.
That's because that sort of dialogue did concern me as well. Him commenting about Mr. Reeves, basically, in a nutshell, about Mr. Reeves' credibility.
And I understand.
And there was a lot of that.
And I wish the rules of evidence allowed me to do that, but I know they don't, Judge. He's not to testify.
Okay.
Judge, the last thing regarding the video is this 6 to 8 second gap that you've heard that term used, throughout the trial so far. And what I'm objecting to is, again, he's commenting on what's not in the video. And this is the way he does it. And this is in the deposition. I don't think so. I would have, again, some of what's missing is the initial attack that Mr. Reeves described. That would have been a point of interest. It's still a point of interest, but it seems to be not captured. So again, he's going back and giving credibility to Mr. Reeves that 8 second gap, giving credibility and saying, yeah, believe Reeves, what's that? So again, it goes to the credibility, and so I would object to that. It goes on, it's just a personal opinion about all the things that may or may not occur, but that's the most important thing because he specifically says, I believe Mr. Reeves.
And again, Judge, we're back to the missing frame things. I have my hypotheses of what occurred during those missing frames as well, but I know that certainly, if I were to testify, I couldn't do it, and I don't think that Dr. Bedard intends to do that. He's not going to talk about the missing frames. He's not going to hypothesize on what may or may not have occurred, or that he expected something to occur or not to have occurred during that time frame. So that's not a bone of contention here.
All right, so let me just clarify real quick about these missing frames. Are we talking about the blue and the black?
Yes, Your Honor.
Unrecorded.
Unrecorded
Right.
because there was no detection of movement.
Or because the sensors were set the camera was pointed in such a way as not to detect movement. There are several reasons given as to why that.
But there's, all of which
Sensitivity.
are basically because it wasn't the greatest system in a short way
The
of saying
system
it.
worked as it was designed.
But there's no indication that somehow, as I didn't hear anything from the expert witness about the missing frames. It's not like somebody came and altered it.
It was an unartful way for me to make that statement. I should have said the unrecorded.
Okay,
It's my fault.
thank you.
Right, and the expert explained that it's because of the sensitivity, the settings of the camera. The expert also testified, well, we'll never know what those are because we never got the hardware and all of that. But that's what we're talking about.
Okay.
Those unrecorded frames. I think.
Okay. Unrecorded moments.
Judge, the next one is a little more complex.
Okay.
Because we're dealing with this self-report method to prize coping, self-efficacy. It's along the same lines as Dr. Cohen testified to. She even testified that that individuals will in fact make decisions based on what they know their limitations were, whether it be mental skills, physical skills. That's the way we go through life, and as we age, those parameters may differ, but our decisions are based on what we know about ourselves. So when we talk about self-efficacy, which is what Dr. Bedard wants to testify about, you read my section in Daubert about that and all the literature. Okay, I don't need to go into that, but here's the main point. First is cumulative to Dr. Cohen. Second is that in order for that to be admissible with an expert under 702, it has to be helpful to the juror. And this is what Dr. Bedard said in the second deposition on pages 28 through 30. Do you agree or disagree that it is common knowledge of adults, if you will, who have certain life experiences, that in making a decision that they will weigh their individual limitations in making the decision on how to complete a specific task? That's pretty common knowledge to everyone, isn't it? Yes, I think so. So we have a situation where we're putting on an expert who has acknowledged that he candidly says, yeah, that's basically everybody knows that. So that would be the cumulative of the second. He's already acknowledged that it would not aid the jury. And then I'll get to the right page. We talk about the self-efficacy. He identified certain things, that Mr. Reeves knows. But again, he acknowledges, just like he did when we had a brief discussion about it, that this is all common knowledge. It's when you make a decision, we take it in our limitations. So I would suggest to the court that we not only have a cumulative argument, but we also have, as an expert, doesn't aid the jury. So I would suggest to the court that you consider that and whether or not he's going to go into this litany discussion about self-efficacy and decision-making process, go on and on, when we've already had one expert very succinctly say, yeah, that's the way it is, and now we're going to do it again? No, that's just cumulative. And he already admits everybody knows it.
All right. I remember much of Dr. Bedard's testimony about this, and there was definitely separate, over and above, if you will, beyond what Dr. Cohen testified, more in the context of combat almost, can I take him, or should I take him, or am I able to take him, or something along those lines. So what about that? What about Mr. Martin's objection?
Well, number one, in terms of cumulative, it's not cumulative because it's definitely in a different context. And certainly, Dr. Cohen was brought up short of being able to put it into context. In terms of the objection, sounds like a Dauber-like objection that it would aid the jury because the person questioned saying that that's pretty common to everyone. But again, it's within context. We all know probably that if it's dark, it's more dangerous. We all know that if it's loud, we can't hear as well. If it's dark, we can't see as well. But what we don't understand is that put together, these factors can have different meaning to somebody who is trained properly. And that's where the whole risk assessment thing comes in, right? You have the threat assessment, so you identify the threat. Risk assessment dealing with human factors, and this is one of those human factors. So really it goes more to weight than admissibility, because really that's what we're talking about in Dauber. This isn't something that's so far within the realm of common knowledge. I mean, Dr. Bedard, I don't know what he thinks about the common person. What we tend to do in this profession as well, we tend to think that people know what we consider very simplistic ideas in our profession. For instance, objection. I see lawyers do it all the time. They'll come into court and they'll speak to prospective jurors as if they know what we're talking about. Some of them do, that's true, but not everyone. So just because his opinion at that time was, well, it's pretty common knowledge, we have to look at it in context. So I don't think it's definitely not cumulative, it's in a different context. And secondly, it will aid the jury in understanding the concept, the human concept, human factors concept of risk assessment.
All right, so what you're saying is that you want him to testify about threat assessment and risk assessment in the context of someone who's been trained?
Yes, Your Honor.
All right, and
That's not this issue. I mean, I'm not talking about training, I'm talking about physical limitations and
okay, but in the context of someone who has this training, that's what I'm getting at.
I'm sorry.
Because if not, then I tend to agree to some point that it is common knowledge. So, in other words, what I'm hoping to avoid is that you're not going to just regurgitate or have him repeat everything that Dr. Cohen indicated.
If I could address that, Your Honor?
Yes?
There's no amount of training that can change the infirmities that come with age. So it doesn't relate to training. It has nothing to do with training. We're going to get to this point in our lives where we make decisions based off of our. That's not any type of professional training. It's apples and oranges.
Well, I'm speaking about what I've gleaned from Dr. Bedard's testimony, that's what he's indicating, that because of his training, he's going to react this way, or a police officer would react this way.
I think that's threat assessment. That's another area.
Well,
No, this is more, they kind of bleed over to each other. Threat assessment, you're looking at what's presented to you as a threat. Risk assessment, you're making a decision based on, in this case, your own limitations, whether that be physical, whether it be psychological, and physical includes not only being older, but not necessarily. I mean, that was Dr. Cohen's testimony. Physical assessment of oneself could be that I'm not that strong. I mean, I don't have to be 71 years old to know that if I'm a 92-pound weakling, that I'm not going to be able to take somebody. So it doesn't necessarily have to do 100% with age. It has to do with size. There are a lot of different things. So, part of the training is you have to assess your situation, including your own limitations. So I think that, for that reason, put in context, the jury should be able to hear that. That's part of the program that's being taught by Dr. Bedard.
all right, so let's keep it from not being cumulative to Dr. Cohen. And,
Right, well, we're not talking about, the aged in particular, we're just talking about physical limitation.
all right. And before you move on, Mr. Martin, before I forget, I remember multiple times an exchange between you and Dr. Bedard about what you would say, so you want to tell this jury this. And Dr. Bedard would say, I don't want to tell them anything. I'll say what I was asked. I'll answer what I was asked. Can we avoid that to some extent? Just
I don't know, because I don't know if I ever got to what he's going to be asked, because the analogy is I was bobbing for apples. I have no idea.
Well, just rephrase, is it your intention to testify if asked? Because it was clear to me what the dialogue and what the offense was in Dr. Bedard's eyes, that he took offense that you indicated he wanted to testify. He wanted to tell the jury things. So that I saw no less than 5 or 6 encounters like that in the reading, and we can't afford that type of banter. But I'm not trying to limit.
Depot, Your Honor.
I know, and I'm not trying to limit. Obviously, you have your strategy, and maybe that's part to raise the ire of the witness. I don't know, but let's try to not do it
I apologize.
multiple times.
I have no idea where the court's going with that. That's not going to come up in the courtroom. That's deposition. That's not proper cross. That's not any.
Right, because if he says something like that in the courtroom, he might not like the answer that
Yeah,
the witness gives him. So if he wants to say it, have that.
Okay, maybe it was an awful way to try to figure out exactly what was going on, but that's not courtroom stuff.
All right. Well, that's what you want to tell the jury. You want to tell the jury. You want to tell the jury.
No.
Okay. All right. Okay. Great. You need a break now?
When we're done with this item.
Okay. I'll give you a break for sure.
Judge, one of the things when we were talking about the talking points and that did not relate to the video was that Mr. Bernard did in fact interview Mr. Reeves. And I don't know if they're going to attempt to get in it. There's a whole different argument.
We're not. He's not talking about an interview with Mr. Reeves and his opinion based on that interview as to what occurred or didn't occur.
Okay.
This is not a forensic psychological examination of Mr. Reeves.
Okay, but one of the issues that came up that I'm concerned about, and I don't want to get blindsided on it without discussing the court, is that for the first time, Mr. Reeves said, oh, by the way, I heard patrons in the theater say the words throw popcorn. Very first time that's ever come up. And so then Mr. Bedard goes through this litany of if he said that, and then he says basically he goes into his reasoning about, well, that might make sense, that not make sense. See what I'm getting at? I don't, if we're not going to talk about anything about the devil, then this doesn't come in. If this is coming in, then we got a whole different argument. So
Are you talking about the part where he said, he comments on the statement you threw popcorn and how the timing of it?
No, Mr. Reeves says he heard patrons say that. He didn't say it. That's what he told Bedard.
Okay.
That's the first time that's ever been said. So I want to know if that's an issue that they're going to bring up, because it is, and we have other arguments.
It sounds like hearsay to me, but I
It does to me too.
I didn't think of trying to get that in.
All right.
All right. Anything
I
else?
think it's a valid theory, though, but I can't elicit it from Dr. Bedard.
Judge, there's the one about, he has a section of knowledge that we discussed dealing with people involved in a stressful situation, an artifact that may indicate and verify that the event was in fact stressful. You might recall that in the definition. We talked about artifacts. Those artifacts being reaction time, different perceptions, cognitive perception differences, television, remember he had a list of all those things. Then what he says is, and I asked him, well, did you see any of that, Mr. Reeves? And very candidly, he said no. He said, I didn't see a lot of this. As a matter of fact, the only thing I saw was some memory issues. I think that demonstrates that at some level, fragment memory also occurs under high arousal. But he also says that that he did not see any of those except maybe fragment memory that went to in the law enforcement manual, I don't recall. If he didn't see any of that, that's what he testified at the testimony, then it's not relevant. You just don't put something before the jury and say A, B, C, and D when it doesn't apply to the defendant. So if it's a non-issue, why would we go through and educate the jury on something that doesn't exist in the case? So it's not relevant, and I would ask that that be excluded because Dr. Bard very candidly said, I didn't see any of that.
So I'm trying to wrap my head around this. On the one hand, the prosecutor said you can't use the interview because that's not legitimate to use in this sort of trial. It's not a forensic examination, my words, but we cannot use that interview. We can't say what Reeves said. Now they're saying, well, based on that interview, and again, we don't know how complete it was, we don't know exactly what questions were asked of Mr. Reeves, that somehow we're going to decide that these artifacts of stress, in other words, what happens when an individual is under stress, again, that Dr. Bedard not only trains others in, but has studied extensively, that he can't educate the jury on what these stressors are and what the manifestation of those stresses are. That makes absolutely no sense. The jury can decide if Mr. Reeves was under that stress or not, if he suffered some artifacts of stress, if they want. But certainly, it's not irrelevant. It's relevant to the whole idea of human factors, the whole idea of risk assessment and making those choices. So, the jury can decide to apply or not. This would be different if the presentation was, these are the manifestations of stress, and these match up with ones that Reeves had or that he didn't have. We're not doing that. We're educating the jury on the use of force, the training of the use of force, and certain things that have been studied. Again, we're not going to cite studies. I know we can't cite studies, but in this individual's experience and his teaching that describe kind of the human condition under these situations. And I don't think that's out of bounds at all, especially since we can't say, well, Reeves didn't say this in his interview with Dr. Bedard, and so therefore it's irrelevant.
Okay, maybe I didn't artfully say that either. Dr. Bedard looked at the law enforcement statement and the prior hearing testimony, right? He also talked to him, that's true, but in using all of those, he did not find any of those artifacts. And if we go to the deposition that was taken on November 19th, it's basically page 101 through 104, where it's kind of lengthy. When I asked on page 103, okay, I want to turn to the residual effects that we've been talking about. And then on page 104, so the artifacts, when I usually look for them, and let me preface my answer by saying I didn't find a whole lot of artifacts. I guess I was surprised. And I think, partly I think during the deposition why I wanted to interview, and that's when he talked about that. He said, here's the problem with Reeves, and I can tell you, see, he knows all of these things. And I mean, if he wanted to fake it, he's aware of tunnel vision, he's aware of auditory exclusion, he's aware of, I can't pronounce those, vas odulation and vas constriction. So he basically said, I didn't see any of it. Well, he never either in the law enforcement interview or at the previous community or anywhere did he say anything that would suggest that he had television or narrowing reaction. So if he's done it, he's said everything, he talked to Reeves, looked at everything, and said, I don't see anything, except for the fragmented memory. And so it's not relevant.
And I don't know that if the prosecutor misspoke or not, but when he quoted the deposition, he said that what Dr. Bedard told him was, I don't see a whole lot of artifacts. In other words, he's not saying I didn't see any that was presented to the court. And frankly, if he's going by that interview, well, we know about the interview by now. It wasn't the greatest interview in the world. Probably Dr. Bedard, if he's asked, would tell you that when an officer is involved in a shooting, usually they wait a day because of these issues. So, I don't see where the prosecutor's coming from in terms of not being able to at least
All right,
discuss stress.
from what I'm hearing, I'm going to overrule as to the artifacts of stress. Okay. We need to wrap this up.
Okay, so now we get to what I've been marching up and down, wearing out the carpet about. It's how we treat Mr. Reeves as and dealing with the issues and decision-making. Is he a law enforcement officer or is he a civilian? And we're going to have the testimony from Dr. Bedard indicating that as a law enforcement instructor, he's aware of how law enforcement is taught. He's aware of the teaching tool known as a force matrix model or force continuum. And I know that might be a foreign concept to you, so may I approach and I'll show counsel what I'm going to hand you. Because I think it's helpful.
We can do that.
Can I approach?
Judge, there was a time when these type of models were prevalent in the agency's policy. I've had this discussion with Mr. Bedard, so I'm kind of parroting what he told me to. It's no longer in the basic recruit manual as of 2007, I believe is what it said. But they were used as a teaching aid. The court recalls that since 1989, law enforcement's use of force has been governed under the Fourth Amendment, under constitutional law. And so someone came up with an idea of how we're going to try to explain these concepts to law enforcement. Now we use simulators, we do a lot of other things, but back then, this is what came out. So what he has done, since when he teaches civilians to help them understand certain parameters to give guidance, drawing the line in the sand, when you're going to shoot or not shoot, he uses these models. As an example, look, if A happens, you can respond this way. And you might be in pretty good shape. If B happens, you can respond this way. You'll probably be in pretty good. It's just a tool visually to help understand so people in their own minds can draw the line in the sand when they are or not going to use a particular type of force. It is not appropriate to use it to educate the jury. And the reason for that is the way he explains it is that the reasonableness of the action is linear. And you go straight across or up or down, whatever, and if you do A and B, that's reasonable. That's what he's going to tell the jury. And that is not the case. And you recall in my discussions in the pleading, we talked about, even in Grant, where objective reasonableness is, you can't decide it in a mechanical way. And that's exactly what this attempts to do. And you can understand why agencies would do it. All right, they want to hold accountability somewhere for the officers or whatever, but that's not the court of law. Our jury instruction will be given 3.6 per NF. You're going to give that to them. And in no way does that concept apply. It's the reasonable man standard. You just don't go, put pigeonhole it here, therefore this is it, and then you don't have to think about it. And that's where we get into the misleading part, when he stops talking about force continuums and matrix, because that's how he explains what is, and I know we're not going to talk about reasonable, but I don't know what's going to, his testimony is going to be. So I don't know what's going to, just like we've had some things come up that we didn't want. I have no idea. So I need to bring this to the court's attention that I object to any explanation whatsoever as to what's reasonable, how to determine what is something reasonable. He can go, look, these are factors for threat assessment, this is factors for situational awareness, here's all the information is, here's the facts, or whatever, but we don't pigeonhole it with this force matrix and continuum, because that's the way he likes to explain his testimony. So, Mr. Reeves isn't a police officer. He's not on duty. This isn't like the officer Potter with the taser and the gun. We're not in that situation. We have a civilian here. That doesn't apply. Of course, the Fourth Amendment doesn't apply to Mr. Reeves. We're nowhere near that. So all this would just be totally confusing to the jury when they get your final instruction. So I object to that as being how he explains how one decides how to respond to a certain response. Because if we look on his second deposition on pages 553 to 554, I assume about the subjectivity of it, and of course the one that can answer the question would be Reeves. I'm aware of what Reeves said, so taking Reeves as true, I would be able to comment on the subjectivity of it and put those behaviors of Mr. Oulson in categories of threat and show the straight line appropriate response. And that would be going back to the objectivity and hindsight. See what he wants to do? That is totally inappropriate. So I object to that.
But that's not what I want to do. Frankly, in terms of that portion of use of force from Dr. Bedard, it's going to be very similar to what the state elicited in the Draker trial. It's going to look a lot like that. There he drew what was essentially a force continuum on a piece of paper. He's going to probably do it on the whiteboard here. He didn't make any comments as to whether it was appropriate or not. And in fact, in this case, it's relevant because we've got to remember that Curtis Reeves was a former police officer who was trained, so I think it's important that the jury understands his training in terms of talking about the Fourth Amendment or objective reasonableness or something. Those issues are not coming up. He's not here to tell the jury that's objectively reasonable under the standard for law enforcement. He's not going to say that it's subjectively reasonable for Mr. Reeves because of his training in law enforcement. I mean, that's not going to happen. He wants to be able to explain, number one, that there's certain categories of use of force, and number two, that there's certain levels of use of force. That's what he wants to show this jury.
So tell that Mr. Rosenwasser address that issue.
Yeah, the only reason that we brought it, obviously I prosecuted the Drake case. So the only reason we brought it up was in the defendant's interview, he was using those terms. He was the one, meaning Drake, used the terms force continuum and force multiplier. So Dr. Bedard was brought in just to explain those terms so the jury understood what possibly the defendant was referring to. The chart that was drawn was only because that's what the defendant was referring to. Now, in this case, you have the defendant, and the chart really wouldn't apply because if you're a police officer, you can one-up level to get compliance from someone, but a citizen can't do that. That's more law enforcement, which is then when you get the bleeding that Mr. Martin's been talking about, that we can't put Mr. Reeves in the position of a law enforcement officer that can, because a law enforcement officer can draw someone down at gunpoint. Now, obviously, if a citizen does that, that's an aggravated assault. So you can't mix and match those two things because the defendant's not a police officer in this case. He's just a regular citizen. So that chart wouldn't apply in this case.
It's to show the jury, to get an idea of Mr. Reeves' training. And one of the issues we have here, frankly, Mr. Reeves was never asked. So let's say, using the state's example, let's say the detective questioned Mr. Reeves as to his knowledge of the force continuum. And then he says, yes, I'm aware of the force continuum. So now we get to use the expert because Mr. Reeves used those magic words to show that he either did or didn't know what the use. No, that doesn't make any sense. And I appreciate that the prosecutor is, and you know, it's creative to say that, you know, we're using it just to define these terms, but the court may have seen the testimony of Dr. Bedard or may not have. But frankly, he wasn't just up there to say, no, that's not what force continuum means. He got up there and drew a chart to show exactly what it meant. So it had a dual kind of effect on the jury, I'm sure, but we're doing it strictly for the purpose of educating the jury as to what law enforcement is taught by Dr. Roy Bedard, who is a police trainer.
Why does it matter what he's taught? Because you can't use that chart in civilian life. I mean, I don't disagree with the fact that they can say he's got law enforcement experience. But that and this issue are completely different.
Well, can't that be brought out on cross as opposed to excluding it altogether?
I mean, the reason that I would say not is because it really is, like, we all understand this because this is what we do for a living. I think for a lay person to understand that is going to be very difficult. And, you know, for that reason, it really would be confusing. They don't understand force continuum, the chart, the difference between what police can do and what citizens can do. And we don't really need that mixing and matching because he's a civilian in a civilian case.
So if I understand that argument, it's confusing to give the jury information. It's not confusing. It's somehow more enlightening to tell the jury in this vacuum that Mr. Reeves was trained for all these years as a police officer, and although he's not being judged by the standards of a police officer, we can all agree that certainly part of his belief as he was, and I know that the court heard a million times, standing in the shoes and sitting in the seat, but it's true. And so, you know, that's why this is necessary, just to give them a glimpse of the, you can't just say, well, you know, this person was a professional dressage jumper. Well, they may or may not even know what dressage jumper is, and certainly they might not know what it feels like to be on the back of a horse or to get the physical training or anything like that. So I just don't see how we cannot tell the jury about Mr. Reeves' education and give them a glimpse of what it is. We're not saying this means that Mr. Reeves acted. That's for argument. They can argue, and certainly they can cross-examine, as the court suggested. You know, this is about gatekeeping, and certainly he's going to be there for cross-examination. If they have a problem with that, they can go after Dr. Bedard and say, hey, what you showed applies to police officers only, doesn't apply to civilians. Let's see how he answers it.
Well, I know it's going to answer because civilians don't have a model. I adapt it and I tell civilians this is what the law is. That's what he's going to say because I've asked him in the depot, and I don't want that in front of the jury. So am I going to ask that question? No. So here's the problem, Judge. We're not saying he can't say, I know behavioral cues. I know reaction time. I know to keep my distance. I know. He can say all of those things, but when you take all those factors and then pigeonhole it in a chart and have him say straight line across, that's where the problem is. I'm not trying to prevent them from saying he doesn't know how to judge whether or not something is a threat based on his training. It's the chart that says if you do this and this, it is okay. That's where I have the problem. That's why the chart doesn't come in. That's why there's no mention whatsoever of force matrix model or force continuum. They can talk all they want about all his behavior cues and how he knows when there's threat and all the things they look for. You just can't put it up there and say linear across, this is okay, because that's for the jury to decide.
And I don't think he says that it's okay in a linear fashion. He says this is what you're presented with. These are the decisions.
What's the relevance of the use of force continuum?
To show Mr. Reeves' education and part of his training.
And the matrix?
And just a way to explain it in a visual way to the jury that there are different categories of use of force and that there are different levels of use of force. I mean, that's essentially what it's being used for.
How is that relevant?
See, there is no national standard for civilians. So he is a civilian. So this is based on Fourth Amendment considerations. And contrary to what Mr. Michael says, clearly he said, Mr. Oulson, I would be able to put Mr. Oulson in categories of threat, different levels on the same, and show the straight line appropriate response. That is just totally wrong.
He's not asking to do that. We're not asking him to do that.
I agree, that's not proper. So, I'm gonna agree with State on that.
So tell me then what he can do. Certainly he can say there are different levels of force.
I knew you were gonna ask that.
Well, I don't want them jumping up. I've
All right,
only been able to
so-
say 3 words in 3 weeks here without them jumping up.
There is no level of force that are, quote, standardized for civilians. Therein lies the problem. What is unique between the law enforcement officers are the cues. How, if you look and saw A, B, and C in a person, posturing, leaning forward, aggressive, those are all common between civilian and law enforcement. They can go into all of that, that's fine. As for if you're going to take, if you look at, say, A, B, and C, then maybe you'd be aware and it would heighten your awareness and you would want to be more cautious. That's fine, but to say, okay, based on his training, he got this, and I'll call it archaic because it's not taught anymore, and it doesn't apply to civilians, and there's no national standard for civilians, then that's inappropriate because that's what he wants to do, straight lines. All the behavior cues are consistent.
Right, okay.
No straight line.
Right, so my question is, the court ruled no straight line. So I'm saying, can I say, are there various categories of use of force? Are there very levels? He won't draw a chart if that's what they don't want him to do, and he'll just say that, and we'll go into the cues and all those other things they talk about.
How is that relevant? Because you're going to go through the different levels. Okay, yeah, if I'm just mouthing off, it's non-aggressive. Okay, non-aggressive, then you can use a pepper spray. See where I'm going? The levels, no. We're getting back to the same thing. We're just orally describing the force matrix. The civilians have no levels. It's either reasonable or it's not reasonable based on their subjective perception of what they saw, period.
Of reasonableness of which civilian? A civilian who has no police training, or a civilian who is extensively trained in the police department? That's
All right, so there's got to be a happy medium here.
I'm sorry.
Go ahead.
Sorry. As of right now, we don't have really any evidence of his extensive training. The only evidence is in his taped statement. He just says he retired from the police department. There is no evidence, because the defendant hasn't testified, about some extensive amount of training. Zero.
Well, Your Honor, I think the court may remember there was a big motion regarding all the certificates and all of Mr. Reeves' achievements. So I think the court is well aware of his extensive training going all the way back to the late 60s. And so I don't know that.
I don't know that's an evidence. In fact, I know the answer is not an evidence.
You're absolutely correct. As we sit here right now in this trial, there is no evidence. That's correct.
Well, that sounds like an issue for later on, either argument that the evidence didn't come out, or the question of Bedard about what he knows.
Okay, so I'm going to glaze over that right now. The happy medium that I'm talking about is I believe that the defense is able to elicit testimony regarding how, police training. But that's about it. He can't project that over to Mr. Reeves and how he acted and why.
He's not going to. We just want to know the training. So is the court all right with me saying, we're going to hear about his extensive training of police forces from United Emirates all the way to Barbados and everywhere in between. And so I can ask him if he trains these police forces and various security forces in the field of use of force, right? I can do that. And he's going to say yes, right?
is that to imply that because Curtis Reeves is a police officer, where Bedard trained him? I mean,
That's silly, but anyway, Judge.
well, right, but I'm saying, what was the point of what you just said?
Because he has police, he trains police officers.
Well,
Mr. Reeves is a 27-year police veteran. That's going to come out. The court can be assured. If it doesn't come out, then guess what? Now they have something to argue in closing. Why did they put this guy up here? He doesn't have anything to do with it. The same thing I argued in terms of opening. I shouldn't have argued, but I did argue a bit in opening in terms of, the prosecutor's opening statement. So, I mean,
It's funny because I brought it out, and then I'm trying not to make it personal, but Mr. Michaels then said that was silly, but he actually agreed that's what the argument was he was making. Bedard does all this training, Curtis Reeves is a police officer, they're trying to overlap the circles that now we know what kind of training Curtis Reeves has. We don't. There's no testimony or evidence at all, other than the fact he's retired police. That is completely all the evidence right now.
experts make opinions over information they're given every single day of the week. We had Dr. Foley in here earlier today giving his opinion over some x-rays that were presented to him. There was no evidence presented prior to this that he had arthritic knees or anything else. That evidence came in because that's an expert's opinion. So I don't see how. So now we're going to exclude. It sounds like what they're saying is we're going to exclude Dr. Bedard now, even though we have a court ruling that he can testify subject to evidentiary issues.
Judge, on this issue, I did discuss it with him, and he said, basically, I'll paraphrase a little bit, Bernard admits he does not know the law enforcement curriculum Reeves received at the Tampa Police Department. That's the first deposition, page 133, lines 18 through 20. Specifically, he does not know the curriculum Reeves received involving use of force or threat analysis. The first deposition, page 133, line 21 through 25. Bernard acknowledges in the 1970s, when Reeves received his law enforcement training, a standard curriculum was only in the developmental stage, and academies were free to develop their own curriculum. That's the first deposition, page 134, line 1 through 9. Bernard finally admits he does not know the specifics of Reeves' law enforcement training. Again, the first deposition, page 134, lines 15 through 19. In response to not knowing the specific of Reeves' training, he stated if Reeves was an instructor, he would know the material. But again, he doesn't know the curriculum of what that was. He candidly testified, I have no idea. So what he's saying is, okay, I have no idea what he was taught. And back then, there was no curriculum. Tampa PD, they had their own academies back in the 70s. St. Pete PD and the agency here, we were at the Votech Center down in Pinellas County. So everyone had their own thing going. They could write whatever they want. So there's no way that Bernard knows exactly what training he received because nothing was standardized. Not until later on when we finally get FDLE involved and they write the curriculum. He admits he does not know the training of Mr. Reeves.
Which is wonderful for cross-examination, but not a legal reason to exclude this testimony. I have a good faith basis to ask Dr. Bedard, and he has a reason for his testimony, and so the state can certainly cross-examine him about that, and that's kind of where we're at. It's not a reason to exclude the evidence.
The good faith basis is the deposition where he says he didn't know?
The good faith basis, frankly, Your Honor, is knowing that my client has served 27 years at the Tampa Police Department, that he's had training from the very beginning, that he's trained other officers, that he started the SWAT department, that he has extensive training in the use of force. He's trained men in the use of force. So that's my good faith basis, Your Honor.
If he testified and all that came out, maybe it's a different story.
That's different than good faith basis.
Yeah. I mean, but there is none. I mean, there's no good faith basis. His good faith basis is because they know Curtis Reeves and they know his background. That's good faith. The witness doesn't know it.
Again, that's
That's a story.
cross-examination.
It's not cross-examination because he doesn't know it. I mean, I can't put it any simpler than that. He just doesn't know it. There's no foundation.
Back then, when he was doing all that, there was no standard curriculum. Tampa PD could do whatever.
So what are you arguing now?
Huh?
What are you arguing now? That he can't testify at all?
No, he just can't testify to his police training because he doesn't know it.
It went back to that, we were talking about how the matrix, and then they said, oh, I just won't draw the matrix. And we're like, no, it's all about the whole concept of the matrix. And that's how we went to, he should be able to testify to the matrix because he is a trained law enforcement officer. And then we segued into, there is no testimony about his training, and that Bedard doesn't know it at all.
That's not, I don't know where they got that from, but I'm sure the court feels like I do, I'm dizzy. I just said that Bedard's going to testify that he trains police officers in the subject of use of force. Right? He's not going to draw a matrix. So that's how this whole thing started. I think that he can testify to that.
All right, the matrix is definitely not appropriate, I think. No chart.
No levels? I mean, we're getting visualization of the chart.
Yeah, the levels are, with the argument that I've got before me, I think the levels are not appropriate either in light of the fact that it appears from prior testimony that Dr. Bedard is not aware of what Mr. Reeves' training is, or that in the years that Mr. Reeves was trained, this wasn't applicable. So I think it's irrelevant.
Well, can I have Dr. Bedard interview Mr. Reeves right now to give us a 10-minute recess so that he has that knowledge, Your Honor? Because frankly, I mean, I don't understand the state's argument. I don't understand it.
Well, how does that solve the situation? It still doesn't reverse your rulings at all as far as orally talking about levels and responses and matrix. It doesn't matter.
It's really just backdooring the defendant's testimony.
What I'm looking at in this chart is stuff that if this is what Mr. Reeves taught and used every day, might have some relevance. However, the relevance is tempered with the fact that he retired 20 years ago plus. So, but the fact that we don't know that he was trained in this and that he used this and this is like riding a bike to him, then I don't see the relevance. So
Then I can ask this, Your Honor. I know. That he trains police agencies, police officers in the use of force, right? That Roy Bedard does.
Mm-hmm.
And part of his training involves something called a force matrix, a force continuum. And he says yes, and then I move on and we talk about other things. Just so later on, should we have the testimony to back that up, now we can link it up, and at least we had Dr. Bedard say, yes, he teaches that.
We're back to it doesn't apply to civilians. This is a tool to teach law enforcement.
all right, I got that. That can come out in cross. I'm going to allow that limited area of questioning regarding the continuum and the matrix under the circumstances. And then you can ask, clearly that doesn't apply to civilians. So I'm done. We're done. We're done talking about this. It's been over an hour, and we're getting nowhere fast. So that's that. All right. Done, right? We're done? That's it?
You told me I was done. I'm not saying
What else do you have, Mr. Martin? What other objections?
Not objections. I know what his response is going to be because, yeah, it does, because there's no standard model for civilians, so we use this. So I'm not going to be able to ask that question. I'm not answering that question.
All right.
So
then that's fine.
That's his answer.
Okay.
So
Okay.
it's just not helpful.
I think the court's asking if Mr. Martin has any further objections other than the ones we've already spoken about. Do I have that right?
Correct.
Yeah.
All right. Then let's take 10 minutes ourselves quickly. a fast 10 minutes?
Well, Judge, after these rulings, I need some time to
I
be able
know.
to sit down with Dr. Bedard. I don't want, something to happen that shouldn't happen.
Well, don't sit down, just stand and tell him. How about that? Let's get that straight. And obviously, we're not going to finish with Dr. Bedard today, but we're certainly not quitting at 4 o'clock.
Judge, can I, on another note, just real quickly introduce the actual pictures that from the thumb drive. Remember, I told you I would introduce the
Yes.
thumb drive,
Yes,
and so this is just VD1.
okay. Good enough.
That's an easy one.
That's an easy one.
VD1.
Be seated, thank you.
Thank you, everyone, you may be seated.
All right, are we ready? I'll take that as a yes. Okay.
You're in the courtroom, Your Honor. You may be seated. I'll do the present accounting for Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess?
Yes.
Thank you. Thank you for returning. We're ready to begin.
Thank you, Your Honor. The defense calls Dr. Roy Bedard.
Please come this way for me, all the way around this way for me, okay? You guys stand right here, raise your right hand and raise the clerk, please.
Do you solemnly swear or affirm that the testimony you shall give in this call shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Go ahead, Mr. Michaels.
Please state your name.
Roy Bedard,
Spell your last name, please.
Bedard.
And what is your current profession?
I am a law enforcement trainer.
And how long have you been a law enforcement trainer?
Oh, I think 35 years.
And we're going to get into that a little bit more. Let's go over your education. I called you doctor, so you have a PhD?
I do.
And where's that from?
It is from Florida State University.
And what is your PhD in?
Educational psychology. My major is sports psychology.
And what was your dissertation?
It was on decision making under pressure specific to law enforcement officers.
Now, you have a bachelor's degree from where?
Also Florida State University.
Okay. And I see an MSc degree.
My master's is also from Florida State University.
And what's your master's in?
Also in educational psychology.
Okay, now you listed on your CV something called Lively Law Enforcement Academy. What's Lively Law Enforcement Academy?
So it doesn't exist anymore. When I went to the police academy, it was run by a vocational school called Lively. And the Law Enforcement Academy was one of the divisions and curriculum of that vocational school.
Okay, so let's talk about police academy. So were you a police officer?
Yes.
Tell me about your history as a police officer.
I began as a police officer in 1987. I worked for the Florida State University Police Department. I moved to the Tallahassee Police Department in 1990 and continued in full-time service until 1996. I went into the reserve status in 1996 and continued with the Tallahassee Police Department until 2015. I retired from the agency, and then in 2019, I believe, I became an administrative reserve for the Tallahassee Community College Police Department.
Okay. And so you're still active in that particular role?
Yes.
Now let's talk about this Lively Law Enforcement Academy. There were certain affiliations you had with that academy. For instance, I see one that says CJSTC. What does that mean?
So in the state of Florida, the Florida Department of Law Enforcement commissions a group of commissioners to govern criminal justice. So the CJSTC is the Criminal Justice Standards and Training Commission that writes curriculum and otherwise interacts with basic level students, as well as agencies for in-service requirements. So they sort of oversee law enforcement. They also issue the standards by which law enforcement officers are permitted to be employed.
And when you say curriculum, are you talking about manuals, books, that sort of thing?
Yes.
And you were an instructor?
Yes.
Okay, so at the Lively Law Enforcement Academy, you were instructor?
Yes.
Now, you also instructed CJSTC as a general topics instructor,
Yes.
as a firearms instructor.
Yes.
You also instructed in the field of advanced injury and death investigations, correct?
Correct.
There's several more that include interviews and interrogations, is that right?
Yes.
And a handful more. Now, tell me about the Florida Criminal Justice Executive Institute. What's that?
The Florida Criminal Justice Executive Institute is also run by FDLE, and it is a executive institute that mostly does advanced and specialized training to administrations, to executives within law enforcement.
Okay. And were you an instructor there?
Yes.
And so one of the things you instructed, I see, elder abuse investigation. Tell me about that.
That actually was a class that I took from that. I did not teach that one. It was precisely as the title says. It was about investigating elder abuse.
All right, so that was a class you took there.
Yes.
Now, you currently, in addition to being consultant, do you own a marketing business as well?
I do.
Tell me about that.
I have a company that is called Rapid Rotation Baton. It has a flagship product that is a police baton with a specialized holster. I also make other types of equipment, including handcuffs and other holsters and belt systems and things like that police officers, correctional officers, and military folks wear. The corporation is a DBA, RRB Systems International, which is the DBA for Rapid Rotation Baton, which is what I mostly consult under.
Okay, now, you're a consultant, so prosecutor always likes to ask, so let me ask you, are you getting paid for your time here by the defense?
Yes.
And how much are you getting paid per hour?
$300.
Okay. And let me ask you this, we're going to get there, but you testified as an expert for the state of Florida, right?
I have.
Not too long ago.
That's true.
This same very office.
Yes.
In fact, one of the prosecutors that's here was involved in that case.
Correct.
And did you charge the state of Florida for your services?
I did.
And what was your fee?
Same fee.
Now, let me look at some of your other experience. I see 2005 to present, Lazarus Mining LLC. Tell me about that.
This was a mining corporation. I was hired to provide consultation and actually boots on the ground services for in terms of their security. It was actually in not the city of, but the country of Colombia. It was a alluvial mining operation.
And so they requested your expertise?
Yes.
In what, training, security? Tell me what
Actually,
you did there.
actually involved in setting up a security system, which did involve training as well as various security analysis of that particular area.
And was that to protect the assets as well as the individuals working
Exactly.
there? Now, you have a title in your CV called Achievements and Titles. So when I see subject matter expert in instructor techniques assigned to reviewing and updating state general instructor training curriculum for FDLE, what does that mean?
So the Florida Department of Law Enforcement Criminal Justice Standards and Training Commission assembles a group of subject matter experts from throughout the state of Florida who sit together and design curriculum. At times they update curriculum, and it's an ongoing process, a work in progress. And I am one of the identified subject matter experts for the state of Florida for developing police and corrections curriculum.
Okay, and so that's general instructor training. What about this? I see same FDLE subject matter expert assigned to updating state defense tactics curriculum and state instructor defensive tactics. Same sort of thing, helping?
It is. There's been many iterations. I've been doing this since the 90s, and so as the state either updates or sometimes completely tears down and redesigns courses, I'm often called for assistance with those projects.
And it looks like those are from 2014, 2013. You have several more instances where you were tasked with aiding Florida Department of Law Enforcement in creating and updating curriculum. Is that correct?
That is correct.
I see one from 1999 to 2003, FDLE, again, Florida Department of Law Enforcement, subject matter expert in defense tactics. So again, you were assigned to drafting state defensive tactics curriculum and state instructor curriculum. Similar sort of thing?
Yes, that was under what we called a CMS curriculum maintenance system that was used back in the late 90s and early 2000s.
And part of your consultation career has not only to do with being a consultant for litigants in court, whether it be an accused in a criminal trial or the prosecution in a criminal trial or civil litigants. In addition to that, you also did some instruction and consultation and presentation internationally. Is that fair to say?
Yes.
And I see you've listed, there are several listed on your CV here. Internationally, I see 2019 Dubai Police Department in the United Arab Emirates, non-lethal technology for law enforcement. You're a presenter.
Yes.
Now, how do you end up in the United Arab Emirates?
I work with particular equipment, and oftentimes if there's an order on that equipment, for example, with that one, it was the pepperball system, I wrote that training manual. So I went and presented it to them in a course that involved field applications.
And I see you presented in Spain, Poland, the Virgin Islands, Israel, Colombia, Madrid, Brazil, Germany, and Scotland. Also, Jamaica, St. Martin, and England. So you've been around the world, have you not, in terms of sharing your expertise and training people?
I have.
Now, you also trained here nationally as well, right? Locally and nationally. So let's look at some of these. 2018 Allied Universal Security Services. You were the curriculum writer for Use of Force and Defensive Tactics program for the largest private security provider in North America.
That's correct.
Tell me about that.
So there's a large corporation that employs many different security officers throughout the United States and abroad. And their Use of Force and Defensive Tactics program, I was commissioned to write that for them.
Okay, and in your notes here, you have between 150,000 employees and over 20,000 sites.
Yes.
You've also been a lecturer at the FBI National Academy graduate meeting, right?
Yes,
Daytona Beach. There you lectured on Stand Your Ground.
that's correct.
You also did a Florida High Liability Police Trainers Conference for the Florida Public Safety Institute. What's the Florida Public Safety Institute?
So that is a organization that is now at the Pat Thomas Law Enforcement Academy in that same location in the city of Tallahassee. And the Florida Public Safety Institute is providing services to law enforcement agencies throughout the state of Florida, as well as other states that may come do training in that area.
Okay. You've also presented to the Florida High Liability Police Trainers Conference, Investigating Stand Your Ground, a presenter there as well.
Yes.
Now I see Florida Public Safety Institute. That's up in North Florida.
Yes, that was the one we just talked about. That is there in Tallahassee. It's actually in a city called Havana, but it's just at the outskirts of Tallahassee.
And I think up there, because I went to school there, they call it Havana.
That may be so.
Now that says lead instructor, FDLE, CGSTC, Defensive Tactics Instructor course. What's that?
To be a defensive tactics instructor in the state of Florida, you have to go through a course called the Florida Defensive Tactics Instructor course. Now, I've both obviously been through that course, and I am certified by the CGSTC as an instructor, but I've also provided that course in many different occasions.
And you also educate, for instance, the Public Defender's Office.
Yes.
Looks like in Fort Myers, self-defense and combat stress.
Correct.
You also spoke to these lawyers in 2012 in Naples, Florida Public Defender's Office. You were a presenter for the self-defense, defense, stand your ground, and castle doctrine.
Yes.
These are all pages of when you presented and some of the instruction you provided. So I'm just looking through them. We went through the the fact that it was international as well as national. So it was not only in Florida, you also have conferences in St. Louis, for instance, all throughout the U.S.
That is correct.
I see something that says karate competition resume. So tell me, were you involved in the martial arts?
I was for most of my life, still am.
Okay. Tell us about your competitive career in the martial arts.
My competitive career, when I was 18, I earned a place on the United States karate team and began traveling with that team throughout various parts of the world, competing in various competitions. And I think I have those listed as well.
And in this case, you also, I should say on your CV, you've also listed some publications and productions that you've been involved in. Publications, you mentioned your dissertation already. I'm looking at one that says Florida Criminal Justice Standards and Training Commission. That's that FCJSTC we've been looking at, right?
That's correct.
And it says Instructor Curriculum, Defensive Tactics, Use of Force, and Survival Stress. Tell me about that. What did you do there?
Again, this is the curriculum that every police officer in the state of Florida and correctional officer has to go through to be able to get their police standards. So I was on the subject matter expert team in writing that curriculum.
Okay. Now, you've helped write the training manual for ground defense for FDLE.
Yes, you're talking about the ground fight course?
Yes.
Yes, that was a corporate course. I have presented it throughout the United States.
Okay. Now, you have been qualified previously, have you not, in the field of use of force,
Yes,
defense tactics,
yes,
human factors,
yes,
okay, among others, right?
yes,
And have you testified in state and federal courts?
I have.
And both for both sides?
Yes,
Now, let's talk about use of force. Use of force is something that you train police officers on.
yes,
Both police officers that have experienced police officers.
yes,
Do you also train, for instance, I don't know if rookies is the right word. What do you call it when you're recruits?
recruits, yes.
And in fact, right now, did you come here breaking away from some training you were providing somewhere else?
Yes, in Seminole County.
What were you doing there?
I'm teaching actually a legal course to what we call a crossover class. These are officers that are currently in corrections but are crossing over to get their license for law enforcement.
Now, let's talk first about this, the subject of use of force. Can you give me a three-word definition for use of force?
A three-word definition for use of force?
Yes.
Oh, I don't know about that, how complete it will be. It is the philosophical underpinnings of force. I used for.
Okay. Maybe it's a clumsy. Is it response to threat?
It is response to threat, yes.
All right. Now let's talk about. You've already established that that's something that you teach police agencies. You teach civilians as well.
Yes.
Now, that use of force, does it always involve a firearm?
No,
Okay. So could it be something other than a firearm?
it can. There are a lot of different tools that can be used by individuals to defend themselves.
Okay. So it could be a weapon
Yes,
of some sort other than a firearm,
yes,
or some other object,
yes,
and it may be even a fist.
yes.
Okay. Now, let's talk about use of force. So there's use of force. There's a kind of a threat assessment involved in the use of force. Is that true, or do I have that wrong?
No, you're correct.
So tell me what that means. Without going in any sort of model or explanation, aside from what does threat assessment mean?
Threat assessment occurs with individuals who are situationally aware. Anytime that you are in any given location, you're monitoring for danger. It's a natural human instinct to constantly monitor for danger. And if something happens in an environment in which a danger signal is noted by an individual, they will begin the threat assessment to determine what level of threat that would be. and it would offer a variety of different cognitive features, in fact, even some physiological features, if the challenge perhaps turns into a specific threat.
Okay. And without commenting on what a proper response may or may not be, when you say certain cognitive, would you use cognitive?
Yeah, some cognitive features. I mean, things.
Tell me about some of those cognitive features.
Well, for example, strategy. Like, if you feel that there's a threat in the environment, what is the strategic best thing to do at that particular moment? That is a rational determination of what is my appropriate response to the threat that I happen to perceive or the challenge that I happen to perceive. And those are different things, challenge and threat. If you, for example, are very close to someone who you think is a threat, a positive cognitive reaction would be to create more distance, for example, or it may be to raise your hands up to protect the vital areas of your body, including your head, your throat, accordingly. So those are features that are taught, they're learned. In some cases, they may even be slightly instinctual. I think we do draw these things from our instincts, and then we codify them in coursework.
And you said certain physiological features?
There are a lot of physiological features as a challenge evolves to a threat. And the basic distinction is when you have a challenge, the assumption is you have the proper coping mechanisms for dealing with it. And those coping mechanisms may be environmental, they may be weapons-oriented, they may be the way you talk to somebody, perhaps in a form of what's known as de-escalation. But when those features are overcome and the challenge evolves to where you no longer have the coping mechanisms, for example, the attack has started and you're not able to avoid the attack, to run from it, to perhaps even fight it because maybe there's differences in size or difference in the availability of weapons or things like that, then that challenge becomes a threat. And when the threat occurs, there are physiological features that start to happen as part of our natural system for self-protection.
And so before we get there, let me go back so I can understand how it progresses. The situation progresses from situational awareness, which means, correct me if I'm wrong, that kind of what it sounds like. You're aware of where you're at, your surroundings.
Right, that's correct.
And somehow just being there with another individual or something else in the environment that could cause a threat.
That would be your threat assessment. When you identify a threat, of course, we are very visual creatures. Most of the information we gather from the environment comes from our vision. So as we're situationally aware, we're paying attention to different things in the environment that may be harmful to us. If we start to attend to a particular thing and identify it as a threat, then we go into threat assessment. For example,
how do we identify something as a threat with our situational awareness? What are some of the cues? What are some of the things that we should look for?
Well, sights and sounds, for sure. I mean, for example, if you step out into the street and you hear the rev of a motor, your threat assessment would perhaps be to get out of the street. So you can hear certain features in the environment, you can see certain features in the environment that would dictate to you that there is an appropriate response to try to avoid danger. For example, moving close to something. When a rattlesnake shakes its tail, it's usually good advice to step back away from that. So that would be a threat assessment, and it would be a reaction to that threat by trying to minimize the chance of harm.
Okay. And when you talk about a physiological aspect, the physiological aspect of this threat assessment, tell me what you mean by that.
I think a lot of times when you teach use of force in defensive tactics, there's a tendency to think that everything is rational, everything is cognitive, and we're capable of thinking about things as if we were sitting at a desk, perhaps learning about it. But in the real world, to use a cliche, there are other things that are happening. There are things that are happening physiologically, chemical and electrical signals that are reacting to your environment as well. Things that you don't have control over, often referred to as the fight-flight syndrome. This syndrome changes the way you perceive things. It changes your abilities, your competencies. It can shunt blood from one part of your body to another part of your body. It changes the way you see. It can generate things like tunnel vision. It can even turn off your ears, something we call auditory exclusion.
And those are kind of artifacts of stress, and I'm going to talk to you a little bit when we talk to human factors, but those are the kind of things that we're talking about. And as I'm talking to you, I can understand that threat assessment kind of boils over into risk assessment. They go hand in hand. Do I have that right?
They do. So once you identify your threat and you start to make cognitive features about that, then you have to do a risk assessment to determine what your best course of action will be.
Okay. Now, when you're identifying a threat, you talked about environment. So, for instance, do you train that? And it almost sounds like we should know this, but certainly, do you train regarding the light available to assess what is a threat now?
Yes, again, being visual creatures like we are, light is critically important to being able to make an accurate determination of what a threat is.
And so when you say an accurate determination of what a threat is, does that mean, at least at this level, trying to determine what the appropriate response is?
Yes.
Now, so when we're talking about light and darkness, you said because we're visual. Tell me about that. Why is a dark situation potentially presents more of a threat if there's another individual that now is becoming a threat? How does that cause that to be more of an acute threat or more of a threat?
Well, at the most extreme with light conditions, if you can't see it, certainly it doesn't figure into your threat assessment. So if it's incredibly dark, for example, you may not see something that is very harmful, and you may not know to do anything about it. As the light improves, you may still have an impoverished view. You may not be able to see things clearly. But for example, somebody who uses a training firearm, it could be painted blue. You wouldn't be able to tell if you were, for example, a police officer pulling up on two people playing with blue firearms, whether or not they were actual firearms or not, because the blue color is only available to you when it's light outside. So as light starts to improve, so too does our acuity, our ability to actually determine what something is, what it means, and it will figure into our risk assessment, our threat assessment appropriately. We do have what are known as mistake of fact. These mistakes are usually when we either don't have enough time to see something or we're seeing something in an impoverished way. We don't have a full picture of it.
And that doesn't mean the person was wrong in what they were thinking, right?
No. And
let me ask you this. So we talked about dark, pitch black. That's an easy one. You can't see it. It's more of a dangerous situation to use a layman's
That is
term.
correct.
As it gets a little more, as there becomes more light in the environment, if it's dim light, does that still affect one's ability to perceive danger and to properly assess the threat? Or to assess the threat?
It can. I mean, obviously in police work, we have tools to make adjustments. For example, flashlights. But of course, that's not always the case when you're dealing with, for example, a civilian set who may not run around with a flashlight. So we try to mitigate the problem as best that we can. But anytime you don't have a complete visual picture of something, it could be said that you don't fully understand it.
Okay, so a police officer has a flashlight. Are they taught, well, if you're not sure, if you can't really see or it's dim, go ahead and light them up if you can?
Yes.
Now, you talked about the idea of, using your senses to do this kind of risk assessment. What about hearing? How does that affect your ability to assess the threat or to perceive a threat?
Well, hearing is interesting because it's probably earliest of our evolutionary features. We tend to hear things oftentimes before we see them. We can hear things at great distances and usually only see things as they get much closer to us. So our hearing tends to be a little bit more acute, especially when you're dealing with things like reaction time. There's been many studies that show that reaction time is faster when it's auditory.
Approach. And Dr. Bedard, could you slow down just a little
I'm
bit?
sorry.
You're probably killing the court reporter.
Okay. Matt?
Go ahead.
We were talking about how the sense of hearing could affect the perception reaction time, and so I don't want to know what studies said. I know that you have a great deal of experience in this field, that you have a great deal of education in this field, that you educate others in this field. So tell me, from your knowledge, how does that affect perception reaction time?
Well, of course, word choice matters. If you can't hear proper word choice, you might not understand a threat in the way that it was intended. There's tone, there's inflection, there's loudness that has to do a lot of times with threat assessment. It's often said that in threat assessment that all creatures will, when threatened, become bigger, they'll get louder, and they will turn colors. And of course, humans are no different. We tend to do that. We pull our shoulders back, we start to holler, and we oftentimes will turn red. So those threat assessments are part and parcel of the risk assessment. What do I do now? And so when you have somebody who's standing in the dark, for example, and perhaps there is some type of a problem with your ability to hear what they're saying, you can't fully understand the threat, and oftentimes these, what we refer to as dymatic threats, where somebody's hollering at you, for example, doesn't really hurt you, but it speaks volumes about what perhaps is coming next. And if you can't focus on those dymatic threats because you simply can't hear them, you will not be able to make an appropriate evaluation of what that threat is.
And what we're talking about now, up to now, that's something you teach. Is that something you teach in police academies?
Yes.
And is that something you instruct civilians on?
Yes.
Now, you talked about the auditory and the visual. When we talked about environment, because you said the first step is environment. And so environment obviously includes the senses that we're talking about. And does it also include the place that this takes place? And what I'm getting at is this. Is it part of threat assessment to take as a cue of a threat or a potential threat behavior that would be out of the ordinary in a certain situation or environment? For instance, if somebody came down the aisle, sat in the front row of court, and jumped up and started yelling, would that start your threat assessment of that individual?
Yes.
And why is that?
Because everything has a baseline. So, for example, if you walked into a church and somebody was jumping around and acting differently than the rest of the otherwise quiet church members, that would be a violation of the baseline. You would attend to that and try to figure out what that meant. To the contrary, if you walked into a club and everybody was really quiet, you would wonder what was going on under that circumstance. So baselines are contextual. And when you're dealing with the context of an environment, you're mindful of those baselines. And what calls your attention normally to things as part of your threat assessment is that something is out of the baseline.
Now, we talked about environment, so let's, that's kind of bigger, macro. Let's micro it a little bit. Does it matter one's proximity to a threat?
Yes.
Okay, and tell me why that's important, how close you are.
Proximity, in terms of the angles that you stand at, for example, affording yourself an escape route, those are proximate decisions that have to be made as part of your threat assessment. But also the nature of how close you are to somebody, which is, I think, how you concluded your question to me, will matter because of reaction time.
And so do you look at kind of nonverbal cues to make that threat assessment?
Verbal and nonverbal, yes.
This is what I'm getting at. I see a lot of police reports, and the police officer will say, well, he was blading.
Right.
What does that mean?
Blading is a bit of a pugilistic or fighting posture that somebody might take by placing one leg back and leaving the other leg a little bit closer to you. This is typically done in fighting as a preparatory stance, and it also is to minimize target area.
Okay. And so that would be a threat, even though there have been no blows thrown.
Yes, that would be what we would call a pre-fight cue.
Okay. Now, what other cues are we looking for in that environment? So we have a close proximity. We have someplace that is not well lighted. We have some sort of auditory interference.
Excuse me, Judge, I'm going to object to the summing up of testimony. I think this is the second or perhaps the third time, so I'm going to object to it.
I mean, I can approach if you want. It's not I could say that if this, that, and that, and that, then ask the question.
All right, I'm going to overrule.
All right.
No objection.
Do those cues, are they cumulative? In other words, the more you have, does it add up to make the situation more of a threat?
Yeah, we would call that the totality of the circumstances, and they are cumulative. When you start adding them together, they're more meaningful than when you take them individually.
So tell me, when you say totality of the circumstances, I kind of know what it means. Tell me what it means in the context of what you instruct police officers, soon-to-be police officers, and civilians. What do you mean by totality of the circumstances as it relates to this idea of threat assessment?
So it encompasses everything that you've talked about so far. What is your environment? For example, it's not a good idea to fight on a slippery floor or perhaps a gravelly floor. You want to have better traction, so you'd want to take note of that. If you're about to engage somebody, it has to do with the lighting conditions, whether or not you're capable of seeing. If you have a tool to your avail, for example, a flashlight, you would probably use that. If you don't, you may choose that this is not the best time to go down that dark alley. There are circumstances about vision. As I said, there may be a case of where an individual is partially hidden and you can't quite see what they're doing, and so that would figure into your threat assessment as well. And then there are also individual features, what we call subject factors, like, for example, how old are you and how capable are you of fighting? Are you bigger than the person? Do you have martial arts experience? Do you have a weapon on you? All of those kind of things would be taken into account when you're trying to examine whether or not this is merely a challenge for which you have the appropriate coping mechanisms, or it is a threat for which your coping mechanisms are now exceeded.
And when you say that, these things are this is part of the totality of the circumstances. In other words, that applies to able-bodied people as well as people that are invalids.
Yes, they're just in a different place in their evaluation. I mean, depending on what, as I said, your individual features are, you would perceive things very differently. You could have two people standing shoulder to shoulder viewing the exact same thing and would assess that threat very differently.
And that's sort of on the risk assessment side that we're going to get to. Would you agree with me?
Yes.
They're definitely related, but it's more properly in that section.
Yes.
All right. Now, one of the things that's interesting that you talked about, well, if you're capable, if you know martial arts. Now, I know that you do. And so I know that I don't. And so if you got close to me and I perceived you as a threat, I would be very threatened. You not knowing me or whether I knew martial arts, you know martial arts, so you probably think you can handle yourself. What I'm asking you now is, if there's an individual that you don't know anything about them, how does that factor into this threat assessment? In other words, all these things we talked about, darkness, out of place behavior, close proximity. So if you don't know anything about this person, does that make this person less of a threat, more of a threat, or still a threat because of the totality?
I think more of a threat. I think, if the attack is on, now we're talking about threat assessment in the course of an advancing threat, you generally assume the worst. And you don't know, for example, if this person, whether they know martial arts or they don't, or they're bigger or smaller, might possess a firearm, which would, of course, be the great equalizer. So you would want to consider the worst case scenario. You'd want to watch the hands, for example, and make sure that they aren't reaching for things perhaps that are now concealed to you that can be taken out in an instant and cause great harm. So yes, for sure, the evaluation of all of those circumstances under threat are going to make you assume the very worst and to prepare for the very worst. Sometimes that preparation may be running away if you have an outlet. Other times it may be that you're forced to engage because there's nowhere else to go.
Okay. And you talked about martial arts, and I know your background in martial arts. So I guess you know the answer to this question. Can a fist cause an injury worse than a bruise?
Oh, yes.
Can it cause a laceration?
Yes.
A cut, in other words, how about a broken bone?
Yes.
Can a fist kill?
Yes.
And does one necessarily have to be trained in martial arts to be able to inflict those sort of injuries on another person?
No.
The risk assessment, what does that mean?
Risk assessment is really trying to determine what the risks are regarding the actions you're about to take, or that you feel that you've settled on. And so there are other things that we started to talk about that need to be taken into consideration. For example, maybe I decide to engage in a fight because I'm left with no other options. Can I take you? Am I capable of actually prevailing if the two of us were to engage in a fight? I'd want to look at how big you are. I'd want to look at how big I am. I'd want to take a look at perhaps your apparent knowledge of fighting versus what I know about myself. I'd want to think about things like injuries. If I have an existing injury, or sometimes the injuries are temporal. For example, let's say we start fighting and you throw me to the ground and I break my arm. I'm certainly not the same person that I was just a moment ago. Now I may choose that I'll disengage from the fight and run away because I don't have that same competency that I had just seconds before. So all of those features that are not only intact, like, for example, your age, your size, but are also temporal, like, for example, your fitness level and your injury level at the moment, have to be weighed into the risk as to how you will proceed with the very next step.
So once you've determined, based on the totality of the circumstance that we talked about, that a threat is present, now we're doing a risk assessment, as I understand it, correct me if I'm wrong, we're doing a risk assessment to determine what the appropriate next step is.
Right, what your next course of action will be that will result in the best outcome for you.
Now, when you talked about, you gave that example about, well, you know martial arts, and so you're aware of what your capabilities are.
That's correct.
You also said something to the effect of, you also may know what your limitations are. For instance, yes, I know martial arts, but I wrecked my shoulder in the gym or something like that, so I know I have some weaknesses. So is that what's called self-efficacy?
Yes.
What does that mean?
Self-efficacy, is the belief that you are capable of handling a task or not, and to what degree you're capable of handling that task. So people have a certain feeling about themselves when they take on any task, not just fighting, but any task, whether you're going to climb the big mountain or you're going to go on the bicycle race or any other, for example, sporting event. There's always a level of self-efficacy that should be improved if you're going to engage. And if you're not capable of improving it, you are at a disadvantage.
Okay. And is that, I heard the term perceived limitations. What does that mean?
So everything is based on perception. Everything that I spoke about is based on what your calculus of, for example, the environment is, what your calculus of the person's abilities are, what your calculus of your own abilities are. Certainly no one has a crystal ball in this. No one knows how this is going to end. So what we do is we calculate what we think will give us the best advantage in any type of a competition. If that competition is for medals or that competition is for life or death, it is pretty much done the same way. If I'm going to engage in this, I want to make sure that the advantage goes to me. And so I want to look at the efficacy of myself to determine whether or not I'm up for the task.
Okay. And so now an individual is doing kind of a risk assessment on his own situation. That's something you teach in police academies?
Yes.
Okay, and to civilians?
Yes.
And what's the purpose of kind of, I don't want to say setting a formula, but of giving these criteria, because certainly they're flexible. Is that true? Do I have that right?
They're flexible, yes.
Why do you teach these things?
Well, it's a dangerous world. It's a violent world, and a lot of times people find themselves in very dangerous or violent situations, and if they aren't prepared for that, they can be terminal situations. It may be the last thing they ever do. So I think most self-defense instructors are not attempting to teach people how to fight or even when to fight, but what to do if they find themselves in a fight. So it's generally what we refer to as defensive tactics. It's defensive in nature.
So is it fair to say the closer a threat is to you, that you are in a more dangerous situation?
Yeah, I think distance is always the great equalizer when it comes to advantage. Even with a firearm, if you get far enough away, then you won't be shot. It's very hard to hit a target that's much smaller, for example, that's off in the distance. Certainly, as you get closer, if we put our weapons away, for example, and we start to use hands and feet, we certainly want to be outside of the range of those hands and feet so that we're not subject to the reaction time principle of being able to recognize a threat and be able to properly respond to it.
And so with a shorter distance, now it sounds to me like what you're telling me is that there are more options for the threat to cause harm. In other words, now the hands are an option if they're close enough, right?
Yes.
And we've already discussed that can cause serious bodily injury.
Objection asked and answered.
Okay. Let's talk about reaction distance gap. What does that mean?
So basically what you just said, which is with reaction time principles, we know them to be about 0.25 seconds. The amount of space that you can cover in a given amount of time based on that constant is the baseline for so much of what we do in self-defense and defensive tactics. For example, in law enforcement, it takes time to draw a weapon out of a holster. You want to make sure that somebody is at an appropriate distance, if you're even going to attempt to do that, that you can actually get the weapon out before being completely consumed by that person because they've closed distance so rapidly. In other occasions, if it's a hand and fist fight, as I said, you want to make sure that you turn every action into a two-step process, not a one-step process. What I mean by that is if somebody throws a hand at you, you want them to have to shift their body close enough to cue you that that hand's coming, to give you the reaction time, because it's going to take about 0.25 seconds to even realize they've moved. At that point, you can assess that movement and you can incorporate the appropriate defensive response because you've given yourself enough time to do it. If you stand toe-to-toe and there is no forward movement, the first recognition of being hit is usually being hit.
Okay. And I know you talked a little bit about stress factors, and I know that your study, your dissertation had to do with that. Tell us, in a situation where there's a threat has been perceived, tell me how stress factors into that.
So again, that particular threat, your body will start to do things that are not within your charge. They will start to, as I said, excrete various hormones, stress hormones into your system, catecholamines we call them, that will change the way that you feel. It will change your perception. It will, in some cases, give you more endurance. It will oftentimes give you more strength. These things that I think laymen call adrenaline dumps. That's really an epinephrine or dump that is a chemical response to fear. It's usually motivated by a part of the brain that is out constantly monitoring for threats. And so those physiological changes will start to occur, and it'll oftentimes change your ability to do things like, for example, think.
Okay. And are there certain physical manifestations of stress?
Yes.
Could you tell me about some of them?
You're talking about acute stress, not
Yes.
chronic stress. I mean, chronic stress is a different
No, I mean acute stress.
area. Acute stress that is sudden, ongoing, and the expectation is that it will be over soon. Some of those things that will occur, and I'll keep it on danger. We'll stick with danger. Is that you will, for example, have a narrowing of vision, something we call tunnel vision.
Now let's talk about that. What does that mean?
It means that your eyes actually start to close in. The acuity of your eyes start to see the threat acutely to the degree that you can't see anything around it. It's often been described by people who are in very stressful situations as looking through a paper towel holder. I think that's perhaps the best image of it. I know that there are circumstances where individuals have been so stressed they've described it as looking through a soda straw. So it's a problem, by the way, for threat assessment when your eye can no longer see things outside of that direct threat. And it has everything to do with the amount of arousal, is the word we use, that you're experiencing based on that threat. And so that would be one of the features.
And again, that impacts somebody's perception.
Yes.
And in terms of anything else, such as narrowing of attention, what does that term mean?
Well, attention means, of course, when you are doing your threat assessment, you want to be as attentive to the environment as possible. You want to see all things. You want to be able to analyze what's important in the environment. You want to be able to gate out the unimportant things, the things that are not threatening to you, so that it's not distracting. It doesn't cost mental energy. It doesn't cost attentional resources, is what we call them. And once you can focus on the important things in your environment, then you become more acutely tuned into those things, but at a cost. And the cost is if something changes in the environment and you are already starting to experience tunnel vision, you may not see it depending on your level of arousal. So there's a fine balance between wanting to be very focused on the threat that you understand and the ability to vacillate things in the environment that might also be threatening to you, that you'll want to see in the event that they suddenly turn into perhaps the bigger threat.
Yeah. And the term distortion as it relates to manifestation of stress, what does that mean?
So perceptual distortions means that you'll actually see things differently, you'll hear things differently, you'll feel things differently, you'll experience things differently. For example, you may experience slow motion timing in a very stressful situation. In some cases, you may experience that things are farther away than they seem. In other cases, you may experience that they're closer than they seem. So your brain kind of plays these tricks on you a little bit and gives you these distortions in perception that other people are not experiencing around you. And you'll see very different, for example, testimony that comes from individuals, the one who is actually under the threat versus the one who is merely observing the threat. They will explain that circumstance very differently.
And so that doesn't make it any less real to the person that's being threatened.
No, it's very real.
Now, to prepare for this case, you reviewed materials like reports, interviews, a videotape.
Yes.
Let me talk a little bit about that. On the videotape, you could see an event that appeared to be the throwing of popcorn and the firing of the firearm. You remember that?
Yeah, among other things, but yes.
That's fine. And then between the time that the popcorn bag was thrown towards Mr. Reeves' face and Mr. Reeves fires, a shot was approximately 0.72 seconds. You remember that?
Yes.
And so in looking at that sequence, let me ask you this. You've looked at the video with the timestamps, right?
Yes.
Okay. And have you formed an opinion as to whether or not Curtis Reeves discharged his firearm in response to Mr. Oulson throwing the bag of popcorn at him?
I did formulate an opinion.
And what is your opinion? Sorry?
I object.
Approach.
Dr. Bedard, do you have an opinion as to whether Curtis Reeves discharged his firearm on January 13th, 2014 in the movie theater in response to Mr. Oulson throwing a popcorn bag at him? Do you have an opinion as to that?
Yes,
And what is your opinion?
that's not why he discharged his firearm.
Nothing further at this time.
Thank you. Cross?
We have just 5 minutes to chat.
Yeah. Do you want me to, are you going to go outside, or you want me to?
No, I just need to scoot around here.
Okay,
Chat for a minute.
all right. Go ahead.
I had to make sure it was still afternoon. When did you start training police officers?
In 1987,
Okay, and that was where?
at the time Lively Law Enforcement Academy.
Okay. And then subsequent with that was in service at the agencies you were at?
Well as I continued on with what later became the Pat Thomas Law Enforcement Academy. I continue to teach there.
And where is that?
It is in the same location. It is actually the same building. It was just simply taken over by the Tallahassee Community College rather than the Lively Vocational School.
And when was that?
I'm sorry?
When was that?
Oh, God. 89, maybe, in the late 80s.
And the teaching that you did was at those particular universities that you previously discussed, along with the agencies that you were with?
You're talking about the earlier testimony? Yes, I've taught all over the world.
No, I'm talking about the earlier testimony when you began teaching.
When I began teaching, I began at the Lively Law Enforcement Academy, and I continued on without break as it transitioned to the Pat Thomas Law Enforcement Academy. I still teach there.
Thank you. No further questions?
All right. May this witness be released?
Yes, Your Honor, he's on standby. We're still
Okay.
speaking to-
All right.
Yes.
Dr. Bedard, you're free to go. If you get called back, you have to come, but I'm sure they'll give you plenty of notice.
Okay.
Thank you. Council approach? right, ladies and gentlemen, I don't know about you guys, maybe it's just Wednesday, but I feel more tired than if it was like 8 o'clock already. But it is 5:16, I believe, according to that clock, a perfect quitting time for this long day. So we will start up again tomorrow at 8:30, and we are in good shape all in all, as I indicated it for our finishing by the end of the week. So, all right. Remember my instructions during the recess, please. No independent research. Don't talk to anyone about the facts of the case. Don't talk about the facts of the case amongst yourselves or anyone else, of course, and don't watch the news. And have a great evening, and I'll see you in the morning. Thanks, everybody.
All rise, court is in recess till morning at 8:30.
Morning. Thank you, everybody. Have a good night.